Hello, everyone. This is Laura from TheRealLauraB here on YouTube and Twitter. And yes, I do have the opening brief that Amber Heard filed. It was recorded 11/23/22 officially. So then, of course, we had the holiday and the courts was closed and they had to get an update. And it was so nice of them to send it out. I did share it with the law tubers, so they will have time to read and analyze. But this is going to be a straight cold read. So, let me do my usual intro, and then we will get right into this. Hang in there.
Hi, I'm Laura, also known as TheRealLauraB from Twitter, and now here on YouTube. I'm a researcher, new wave internet media, and commentator. I'm not a lawyer, nor offering any legal advice. Join me on a journey to review the world of celebrity lawsuits and current events. Let's get started.
Hey everyone, here I am back. So bear with me, it's a cold read. Don't get upset with me if I'm messing up. But it came in at, it looks like 4:41, and I think they close at 4:45. That's their normal hours. So yeah, hello everyone. Thanks for coming in. It was a crazy day, but I expected this would be coming in. I took a break over Thanksgiving for 4 days. I know the amicus briefs dropped. I did read them. I did have a chuckle. I did have some confusion with them, as everybody else did, but a lot of people covered them, and they basically were all saying they were mostly for PR. I don't think she's covered all 16 of her assignments of errors. That will be something that we can compare and contrast maybe later on. So hello, everyone. Thank you for coming in. I so appreciate it. I don't know that I got her. Let's see. Well, I let everyone come in for a minute. Let me see if I did have her assignments of errors originally. I know I have it. Opening brief. Yeah, so she had 16 assignments of error. After we read it, we'll go through this and see if she skipped any, but I think the brief is what's a priority. So please like, share, subscribe, check those subscribe buttons because people keep getting turned off. We're getting a nicer group in here, so maybe we should just get started. So this is what we've got, guys. Let me zoom in. She did not go the fancy route like Johnny did. See if I can make this as big as I can. Great. So again, this was filed, if you see over here on the side, November 23rd at 16:41, 4:41, 4:45. I know they close. So that's why it wasn't updated. He's just getting all updated this morning. So it was very nice that they sent it to me. J. Ward Brown, David Axelrod, and Ben Ronborn. So the table of contents, we have our table of authorities. That's going to be all their legal citings, statement of the case, assignments of error, and statement of the facts, and then the argument. So we're going to get right into it rather than read through this because it's going to be a repetitive anyway. Conclusion, table of authorities. So it's Virginia, U.S., Virginia. So they are citing Virginia cases, U.S., I assume Supreme Court cases, Virginia, U.S. So they are citing quite a few local cases. That's important for them. What did we look for? Pendleton. See if they brought Pendleton in. Yes, Pendleton is here. That's a key one for defamation by inference or innuendo. So let's, what else? And again, the law tubers are much more into these cases than I ever could be. They're using Virginia code. They're using the Virginia rules and the U.S. Constitution. So here's our statement of case, guys. You ready? 68 pages is 50 pages maximum. I'm not sure when the page numbers start to be counted, but yeah, 68 pages. So maybe the signature pages and maybe, I'm not sure what else, but I thought she was given an extra 5 pages. So let's see what we do. In 2016, appellant Amber Heard obtained a domestic violence temporary restraining order against her then husband, appellee John C. Depp. Appellee. 2 years later, Heard authored an opinion piece ultimately published by the Washington Post in which she discussed the public backlash she had experienced after that legal proceeding and advocated for policy changes to support women who report gender-based violence. Heard took great care not to mention Depp or to repeat her prior allegations of abuse by him, but Depp sued Heard for defamation, claiming she had revived her 26 allegations merely by describing the reaction to them. No, you said 2 years ago, and this was the only person that you had ever made claims against. So you didn't go to great pains to keep him out of this. And ACL has all those emails to testify to that. Instead of suing Heard in California, where both parties lived and where Depp claimed to have suffered reputational harm, Depp sued in Virginia, a wholly inconvenient forum with no connection to Depp or any meaningful connection to his claims. The trial court erroneously refused to dismiss this action on the ground of forum nonconvenience, based on its mistaken conclusion that Depp's claim arose in Virginia because the Washington Post servers are located here. The trial court also erred in overruling Heard's demurrer, in which she argued that the challenge statements are non-actionable expressions of opinion and are not reasonably capable of conveying the alleged defamatory implication. That holding, if allowed to stand, undoubtedly will have a chilling effect on other women who wish to speak out about abuse involving powerful man. No, if you're going to speak, if you do things through legal forms, if you call the police, if you file court documents, you cannot be sued for defamation. That's all protected speech. And this filing that was made at the time with Roberta Kaplan, that was the famous statement that anybody with a grasp of the English language would know that this was not about Johnny Depp. This case also should never have gone to trial because another court had already concluded that Depp abused Heard on multiple occasions. After Depp filed this case, the United Kingdom High Court of Justice ruled in a separate defamation action brought by Heard that Heard's abuse allegations were true. No, not that they were entirely true. At the civil level, the trial court should have given preclusive effect to that 129-page decision, which followed a 3-week trial at which Depp, Heard, and 24 other witnesses testified. Once this case did go to trial, Depp failed as a matter of law to meet his burden to prove actual malice by clear and convincing evidence in 2 ways. First, he did not demonstrate that Heard was aware of and intended to communicate the alleged defamatory implication that he had abused her. He did not demonstrate that Heard was aware of and intended to communicate the alleged defamatory implication that he had abused her. 2 years ago, when I became, he's the only one that she was married to. She was the only one she made claims against. He was. Second, he did not establish that Heard knew the alleged implication was false or subjectively entertained serious doubts about its truth. The trial court erred in declining to set aside the jury verdict and enter judgment in Heard's favor. So they're going with that she believed she was abused even if nobody else did. We all saw the trial. We all sat through it. As the 6-week trial unfolded, the trial court made numerous evidentiary errors that severely prejudiced Heard, both by excluding highly probative evidence and by admitting irrelevant and prejudicial evidence. The trial court further erred by not dismissing one of the challenge statements because the undisputed evidence showed that Heard simply did not publish it. Okay, so what I've gotten so far from binging on the videos this weekend, the LawTubers, that evidentiary appeals are very difficult, very, very difficult. And as far as Heard did not publish it, she did republish the title. The article had the title. She republished it on Twitter. She added commentary. She shared it to her followers, which are probably not wholly Washington Post followers. What didn't come up at trial, she also screenshot it and put it on her Instagram, which got tens and tens of thousands of views. And when she screenshot it, you could see the title. So she very well saw the title. That didn't come into court. The trial court then refused Heard's proposed jury instruction on the cumulative intent prong of actual malice. Consequently, the jury instructions were missing a key requirement for establishing a defamation by implication claim. In addition, the resulting jury verdict against Heard on all of Depp's claims cannot be reconciled with the jury verdict against Depp on Heard's counterclaim. So they're saying that because they found for her on one of the 3 statements that can be reconciled, that they should have found for all 3. But we know that the second one was far more detailed. And that's why they could have found that way. And all the LawTubers agree with that. And so did Judge Ascarate. To find in favor of Depp, the jury must have concluded that Depp did not abuse Heard and that Heard knowingly lied in accusing him of abuse. But to find in favor of Heard, the jury must have concluded that Heard told the truth about being a victim of domestic abuse by Depp. Accordingly, the verdict cannot stand. But in favor, by finding the one statement for Heard, remember, because it was so detailed, the fact that, say, Adam said the lawyer told them to get their story straight could have been what they found defamatory. So it's the one statement was far different than the other two. Finally, even if this court were to disagree with the foregoing, the jury's award to Depp of $10 million in compensatory damages and $5 million in punitive damages, statutorily reduced to $350,000, clearly is excessive given the narrow time frame from which Depp would recover. Well, that was presented, and that was the jury's. Assignments of error. Trial court erred in declining to dismiss the action on the ground of forum nonconvenience. Trial court erred in denying the supplemental plea and bar, which is the UK ruling. The trial court erred in denying the demurrer and plea and bar, which is, this is just an opinion, expressions of opinion. The trial court erred in excluding the evidence at trial, the November 2nd, 2020 judgment of the UK. So they wanted the judgment in. The trial court erred in excluding from evidence at trial medical records reflecting Heard's contemporaneous communications with medical providers, such as, so she's going with all of this, of all the doctors, the hearsay that's always been ruled hearsay, your self-reporting, Heard's contemporaneous communications with several third parties, including Depp's employees, Heard's employees, friends, and families about interactions with Depp, including reports of drug use, aggressive and abusive conduct. Well, this is going to go to, for example, Stephen Deuters. I did a video on this where they proffered that they wanted Stephen's text in, but they didn't want his deposition. They wanted him to be labeled like Adam Waldman, an agent. So they wanted to introduce the text without his depositions, which of course would be hearsay. So that's just an example of one from there. We saw all of these testimonies except for Bonnie Jacobs, right? That went through the hearings on Fridays about what the video part of the depositions could be shown. The trial court erred in admitting irrelevant and unduly prejudicial evidence at trial related to Heard's pledge to donate money to charity and evidence related to Heard's alleged abuse of third parties. Well, one, the donating money that she lied about shows her propensity to lie to the public to get what she wants, to make herself look good. And that goes with the same thing with lying about, well, potentially lying about Johnny's abuse. And as far as the abuse of third parties, she introduced that when she said, I know it's wrong. You can't hit a woman. A woman can't hit a woman, can't hit a man. You can't hit anyone. And that's what pretty much opened the door from that. And I did a video on that from the unsealed documents where they had a hearing. And they were pretty limited in what they could bring in because they certainly couldn't, they wouldn't classify, what's her name again? I just went blank. The arresting security person at the airport as an officer of the law, which I found interesting. The trial court erred in excluding evidence at trial of Depp's reputation as it existed prior to publication of the challenged op-ed and after the op-ed was published. Well, we saw tons of reports on that. They introduced all those headlines. They had their experts come on to show. So I think the jury, I mean, he was asking for 50 million. So they obviously reduced it to what they believed happened in that period after the op-ed. The trial court erred in sustaining an objection during the cross-examination of Depp to question about the, I cannot believe they're bringing this one in. The trial court erred in sustaining an objection during the cross-examination of Depp to a question about the truth of one of the allegedly defamatory statements on the grounds it called for a legal conclusion. Out of all of the questions that were asked, of all the objections, they are seriously taking a 6-week court and complaining about one objection that they feel changed the entire course of the verdict and worth appealing. Wow. The trial court erred in allowing Depp to argue or suggest at trial that the jury could award damages based on statements or conduct occurring prior to the publication of the challenged op-ed. Could award damages based on statements or conduct. I'm only assuming they're talking about the TRO, but we'll see. The trial court erred in allowing Depp to argue or suggest at trial and the jury to consider whether the allegedly defamatory statements in the challenged op-ed were republications of statements Heard made in 2016 in connection with the domestic violence temporary restraining order she obtained against Depp. So basically what they're saying here is when she referred in the article to 2 years ago, this happened to me, they're saying that that information was wholly contained in the TRO filing, which would be considered protective speech and cannot be used against her in defamation. But they're going to forget that she also released all these interviews and this huge people spread that's not protected speech. So that's just my non-lawyer opinion here. Trial court, which rejected proposed jury instructions CC, improperly instructed the jury on actual malice. The trial court erred in denying the motions to strike and to set aside the jury's verdict with regard to Depp's failure to prove publication by Heard of the statement, "I spoke up against sexual violence and faced our culture's wrath. That has to change." Well, we know that that was greatly discussed back and forth, that she had republicized it, therefore she adopted it. And she never asked for it to be changed. The trial court erred in denying the motion to set aside the jury's verdict with regard to Depp's failure to prove that the allegedly defamatory statements in the challenged op-ed each conveyed a defamatory meaning about him by implication, and that any such implication was both designed and intended by Heard. Heard said 2 years ago this happened to her, that she was a victim. That was intended by Heard. I mean, granted, the ACLU wrote most of the op-ed, but those statements were from her personal experience, and they were intended to be about Depp, unless she's going to come up and say somebody else did it, which she didn't in court. The trial court erred in denying the motions to strike and set aside the jury's verdict with regards to Depp's failure to prove actual malice by clear and convincing evidence. The jury didn't agree. The trial court erred in denying the motion to set aside the jury's verdict and ruling that the jury's verdicts in favor of Depp on his claims against Heard and in favor of Heard on her claims against Depp were not inherently irreconcilably inconsistent. So that's again saying that how could they find for Depp on all three statements and on Amber's side find for her on one of them? That's inconsistent. It makes no sense. That's been discussed ad nauseum, that they are different. The trial court erred in denying the motion to set aside the jury's verdict and upholding the amount of the jury's damages award in light of Depp's failure to prove pecuniary damages and the excessiveness of the compensatory damages. So they're going for everything here. All 16, they're throwing it all at the wall. How are we doing in the chat room? I'm not going to be able to follow it because of the first read. How are we doing? In order to appeal the court, basically. Yeah, they want it thrown out. They actually don't want a retrial. They want it thrown out. They want it completely thrown out, overturned, the whole deal. At worst case, they'll want a retrial, which I guess it would be up to JD if he would want to retry it. Whew. Yeah, go listen to the tapes. They're trying to, this is not showing, there it is. My biggest legal question for the lawyers is if they concentrate on pre-trial things on their appeal, does that mean they can't bring in what we already know at trial? Well, in other words, the jury found for Johnny, the jury didn't believe her. So I'm going to keep reading because it's long. Statement of facts. 2016 domestic violence proceeding. Depp and Heard are actors who first met in 2009. They married in 2015, but their marriage was short-lived. In May 2016, Heard filed for divorce and for a DVTR order against Depp in Los Angeles Superior Court. In support, she submitted a declaration describing his temper, paranoia, and substance abuse issues. Heard also alleged that Depp grabbed and pushed her, threw a cell phone at her face, pulled her hair, smashed wine bottles in her vicinity, destroyed her personal property, and threatened her. After the hearing, the court granted the restraining order. Again, this was an ex parte hearing that Johnny Depp, La Rosa, was not notified and he was unrepresented. That came out at court. According to Depp, he lost nothing less than everything from the second Heard applied for the restraining order in 2016. The accusations were widely reported in the media, and Depp quickly became associated with them. Once the divorce became final in January 2017, the parties issued a joint statement confirming neither party made false accusations for financial gain. Well, at least they finally added that part. They also said that nobody abused each other either, or there was no intentional. Depp's lawsuit against The Sun, British newspaper. The Sun published an article on April 27, 2018 that referred to Depp as a WB. I got to be careful of YouTube, guys. On June 13, 2018, Depp sued The Sun for libel in the UK, Depp v. News Group newspapers. He alleged that the Sun article had caused serious harm to his personal and professional reputation. The Sun asserted the defense of truth, containing that Depp had harmed her. The parties to the UK proceeding engaged in full discovery not at the U.S. standards they didn't. And Judge Ascarati was very definitive about that point, culminating in a 3-week trial with 26 witnesses. Although not a party, Heard was an active participant, providing evidence that she chose to provide, cherry-picked herself because, again, the judge would not compel her and not allow Johnny to seek evidence or provide evidence from the Virginia that had been marked confidential, although Heard was able to. Just my interjection there. Heard was an active participant, providing evidence in 7 witness statements and testifying for 4 days at trial. Depp had access to 16 months of discovery in this litigation, which he used in the UK proceeding. On November 2nd, the UK court issued a 129-page dismissing Depp's claim against the Sun on the basis that Heard's prior allegations of abuse were true. I thought it was substantially true. UK judgment. Specifically, the UK court found sufficient evidence to establish that at least 12 incidents of abuse had probably occurred, I think. This isn't a criminal trial, so there, of course, the lawyers in the appeals are going to know this. Depp had exhausted his appeals, leaving the UK judgment in place. No, he didn't exhaust it. He was denied permission to appeal, which is completely different than here in Virginia. That in the US, you were allowed to appeal. He wasn't even allowed permission to appeal, even though he came up with what he felt was plausible. Oh, the op-ed. In late 2018, while the UK proceeding was pending, the American Civil Liberties Union invited her to serve as an ambassador on women's rights and proposed that she author an op-ed advocating for policy changes to protect victims of gender-based violence. Remember, all of these are citations in the court record for the appeals judges to go look at. The Washington Post published the op-ed on its website on December 18, 2018, and in print December 19th. Heard then posted a link to the online version from her personal Twitter account and added commentary. Oh, gee, they forgot to add that. And it had the title of the sexual violence in it. Oh, they didn't add that. Depp's lawsuit against Heard. On March 1st, in 2019, Depp filed his action alleging that although the op-ed never identified him by name, it revived the domestic abuse allegations Heard had made in seeking the 2016 restraining order. Depp based his claims on 3 statements. The headline for the online version, Amber Heard, I spoke up against sexual violence and faced our culture's wrath. This has to change. 2. Then 2 years ago, I became a public figure representing domestic abuse, and I felt the full force of our culture's wrath for women who speak out. Is there any reasonable reader out there that would not know that 2 years ago she accused Johnny Depp? I had the rare vantage point of seeing in real time how institutions protect men accused of abuse. Relevant pretrial proceedings. Heard initially moved to dismiss the ground on forum nonconvenience, which the trial court denied. Heard then filed a demurrer seeking dismissal of all claims, arguing that the challenge statements were not actionable as defamation by implication and that all but one expressions of non-actual opinion. Trial court overruled the demurrer. All but one. There was a 4th statement that saying I had to change my phone number, et cetera. That was not found to be defamatory. So there was 4 statements that Johnny Depp originally claimed. 3 stood. On August 10, 2020, Heard filed counterclaims against Depp, including defamation claims arising from 3 statements made by Depp's attorney, which is also on appeal. The April 13, 2021, while the parties were engaged in discovery, Heard filed a supplemental plea in bar after the UK judgment had become filed, arguing that Depp should be precluded from relitigating the UK's court finding with her domestic abuse accusations were true. At the civil level, the trial court overruled the supplemental plea in bar. As Judge Ascarati said, different country, different laws, different judicial procedure, no jury, which is very respected here in the U.S. So a single person made that decision. He also participated in all the pretrial admissibilities, which really confused me. Amber Heard was cross-examined. I know that's been confused. Johnny Depp's lawyer, Eleanor Laws, cross-examined her, but she was not compelled to provide any evidence. She was able to cherry pick. Much of the evidence that she used was in Virginia marked confidential. When she used it in the UK as part of the rule for them not to dismiss the case to start with, was Johnny was not allowed to pursue any actions in Virginia or sanctions against Amber Heard for releasing the confidentially marked discovery to the UK. This is what Adam Waldman entangled in as far as what was released and what was not allowed to be released. It was such a mess for everyone, but Amber was protected. So, I mean, different article, different plan. She was not a party. Everything was different. So Judge Asgardi upheld it not once, but twice, that they could not dismiss it based on the UK, and she would not allow the UK ruling, etc., into trial. Depp should be recluded from relitigating the UK's court finding that her domestic abuse accusations they're not true. This was not a beyond reasonable doubt. This was not a criminal trial. This was a civil trial. So they're not true. They are maybe substantially at the civil level. The trial court overruled the supplemental plea and bar. So now we go to the trial. On April 11, 2022, the case proceeded to a 6-week trial, notwithstanding that Depp focused on attacking Heard's credibility and portraying him as a liar. The court precluded Heard from introducing documents and other evidence corroborating her accusations and allowed Depp to admit irrelevant and unduly prejudicial evidence that he further used to attack Heard's character. At the close of Depp's case, Heard filed a motion to strike the evidence on multiple grounds, which the trial court denied. On June 1st, the jury returned a verdict in favor of Depp on all of his claims and in favor of Heard on one of her counterclaims. The jury awarded Depp $10 million in compensatory damages and $5 million in punitive damages, which the trial court reduced to the statutory cap at $350,000 pursuant to the code, which the jury would not have known about, which I now that it's been published so much in the press that any other Virginia jury will probably know about this now. Depp asked for $50 million. He didn't get his $50 million. So they did narrow the scope as ordered by the judge. Anyway, Heard was awarded $2 million in compensatory damages. On July 1st, Heard filed post-trial motions on a number of grounds, which the trial court denied without argument or opinion. I read an opinion. And there wasn't an argument, I don't think. Well, no, Depp did file a reply. Anyway, the trial court erred by not dismissing Depp's claims prior to trial. So here's what we're finally getting to the argument. Let me just check. Thank you, Kat Wagner, for the super sticker. I so appreciate it. I think that's all that's popping up. So does she have to pay the money she was meant to donate? Yeah, well, that would be up to the charities to go after. Good morning, everybody. I know this is a quick read, but we're now getting into the meat of this. They can only bring up what went on at trial. Yeah. Charities can't sue. They can if they can somehow prove there was some contract involved, like you offered to donate and we named a wing after you and then you didn't donate. You know what I mean? Like there has to, but so I'm not thinking in this case, although she benefited from the press, but it always makes them look bad to go after. I mean, the UK and Age side always goes on about it like Age was the star witness. She was the star witness. The sad part was she wasn't treated equally. She was giving more weight than NGN and not having to provide the same evidence and stuff. Okay, I think we're doing pretty good. I'm going to get into this. So they did bring all 16. I'm amazed. I'm surprised. Thank you. Here it is. Thank you. I'm catching up real quick before I can catch my breath and having a little sip. It's definitely tea time, and I'm losing my voice having to read this, and I will slow down a little bit. I'm like, all right. Here we go. Argument. The trial court erred by not dismissing Depp's claims prior to trial. For each of 4 independent reasons, the trial court should have dismissed the action prior to trial. The grounds of forum nonconvenience. This case should never have been tried in Virginia. The record overwhelmingly demonstrated that Virginia had no meaningful connection to Depp's claims and that California was the only appropriate venue. The trial court therefore erred in denying Heard's motion to dismiss the action for forum nonconvenience. Depp's claims should now be dismissed without prejudice for this reason. So without prejudice means that they are saying you should forget the trial ever happened. Sorry, let me go back here a minute. Forget the trial ever happened. Dismiss it, but without prejudice, meaning they're allowing Johnny to refile in California. Versus with prejudice, which I'm sure they're going to have later on. Virginia's forum nonconvenience statute permits a trial court for good cause shown to dismiss an action brought by a person who is not a resident in the Commonwealth without prejudice. If the cause of action arose outside of the Commonwealth, and if the court determines that a more convenient forum, which has jurisdiction over all parties, is available in a jurisdiction other than the Commonwealth. If the cause of action arose outside of the Commonwealth, it arose inside the Commonwealth, and that's what the judge ordered. By filing in Virginia, Depp presumably sought to avoid California's strong anti-SLAPP law, which has given rise to an early motion practice in California defamation suits that provides a potentially potent weapon for defendants. So this was the sack on defamation that they had cited above. If Johnny had filed in California, she would have filed her anti-SLAPP defense. Johnny would have had to present presumably what he had available to him at the time. She would have fought that the op-ed was in the public concern, and there was probably a good chance it would have been dismissed because they wouldn't have heard the evidence. They wouldn't have been able to get into what the concluded jury said was that she lied and he didn't harm her. If the cause of action arose outside of the Commonwealth, it didn't. It was published by WAPO in Fairfax County. A court abuses its discretion when it makes an error of law. Here, the trial court made an error of law in concluding that Depp's defamation claims arose in Virginia rather than outside the Commonwealth. Had the trial court correctly applied the law in this regard, it then would have been required to consider whether a more convenient forum with jurisdiction over both parties was available. The evidence before the trial court clearly demonstrated that California was such a jurisdiction, but because of its erroneous legal conclusion, the trial court never even considered the substantial inconvenience and prejudicing litigating in Virginia would impose on her. Well, they have a rule in California. They have a rule in Virginia that if you live outside, I think it's 100 miles, they cannot compel you to show up for testimony. They can use your deposition as video testimony. So that's already in place. So that takes care of the inconvenience. So the only inconvenience was to Heard and Johnny. She could have given her testimony, I assume. No, I think the judge wanted them both in court. But they did make further allowances to allow testimony via live links. Hey, Nate, she finally filed. This is not looking good for H, but we'll see. The amicus was also awful. Yeah, I sent you the link in the chat room. I'm sure you got it. Thanks, Nate, for watching. And yeah, it's all 16. They threw everything at the wall. They threw it all. If there is a retrial in the U.S., we know that H has said on the stand that she wrote the eb twice. Yeah, if there's a retrial, I think everything will come back in that's already said unless somehow the appeal says it doesn't stand. And but I think Johnny has to bring he has to file to bring it to trial again. So maybe Nate can throw it up. That's so nice. Yeah, she's doing it all. All 16 are here. The amicuses were awful. I let you all cover them. Whew. Here we go. Depp's defamation claims arose outside of Virginia. Let's do this so I can see the chat a little bit better. Maybe I can make this a little bit smaller. Hold on, I catch up. Thank you, Diana. I'm just checking in case Nate says something. The trial court ruled that Depp's defamation claims arose in Virginia solely because the Washington Post uploaded the op-ed to the internet via computer servers located in Springfield, Virginia. That ruling is inconsistent with Virginia law as applied to internet publications, which dictates that Depp's claims arose in California. Virginia adheres to the rule of lex loci delicti, or place of the wrong, to determine where a cause of action arises. For defamation claims, Virginia courts have defined the place of the wrong as the state where the content at issue was published. Neither the Virginia Supreme Court nor this court, however, has addressed how that rule applies to defamation claims based on internet publications with reach and audience in multiple states simultaneously. But that was the point where they hit the enter button. That was the point that it was published. The trial court incorrectly concluded that publication for purposes of online multi-jurisdictional cases occurs when the defamatory statement is uploaded to the internet. To the contrary, under Virginia law, a statement is not considered to be published until it is seen or heard by a third party. Uploading content to the internet is not enough to constitute the completed tort of defamation. Instead, a third party must also receive and understand the content. Because the op-ed reached readers everywhere at once, the trial court had no basis to find it was published in Virginia rather than California or anywhere else. Well, it was certainly the point that it was published. They didn't hit it. The server wasn't in California, so it could not have reached California. Thank you, Mandy. Until it was published first in Virginia. It's going to be interesting. And this was sussed out quite a bit in the discussions with Judge White. And in fact, one of the few transcripts of hearings is still on the Fairfax site. I'll link that below, if I remember. Uploading content to the internet is not enough to constitute a completed tort of defamation. Instead, a third party must also receive and understand the content because the op-ed reached readers everywhere at once. I know I just read this. The trial court has no basis to find it was published in Virginia. I don't think they're suggesting it has to, like, one person has to see it first before it counts. Numerous courts interpreting Virginia law have concluded that the place of the wrong for internet defamation claims is where plaintiff incurs the greatest reputational injury, which typically is their own home state. So they're bringing in Nunes. Here, that state was California, Depp's home, and the trial court abused its discretion in holding that his claims arose in Virginia. Well, there's plenty of argument that can be made here that as a global actor, he works globally. He's not an employee of a studio located in California. He has multiple residents, but his reputation that he can be hired pretty much anywhere goes beyond his residence. Thank you, Cher. I so appreciate it. Virginia was a completely inconvenient forum because the trial court erroneously concluded that Depp's claims arose in Virginia and Heard therefore had not met the prerequisite to dismiss the case based on forum nonconvenience. It did not consider whether there was good cause to dismiss the action. Good cause includes, but is not limited to, the avoidance of substantial inconvenience to the parties or the witnesses. Thank you so much, Chris. I so appreciate it. It did not consider if there was good cause, avoidance of inconvenience to parties or witnesses. Had the court analyzed good cause, it necessarily would have concluded that Virginia was a completely inconvenient forum for this case. None of the conduct relevant to Depp's defamation claims occurred in Virginia. Well, she republicated it. Depp is a resident of California. The incidents that led to Heard obtaining the restraining order took place in California, not Virginia. Heard wrote the op-ed in California and then sent it to the ACL in New York. The ACLU provided the op-ed to the Washington Post, which published it online. Heard had no contact with any Washington Post employee. To the best of her knowledge, Heard had never set foot in Virginia prior to the lawsuit. I can't believe they're rehashing this one. In short, Washington Post computer servers presence in Springfield is the only connection between these claims in Virginia, which means Depp's choice of forum is entitled to little weight. Indeed, to the extent Depp incurred any reputational injury, the harm occurred in California, not in Virginia. I don't agree. This was greatly contested. That transcript is really interesting. Little weight. In contrast, both parties and most of the fact witnesses were located in California, with none of them located in Virginia. So this was hotly discussed about what publication would be. Somebody asking her to write this, her writing this, ACL supporting it. Obviously, they wrote a lot of it. It's really when it was published. I mean, one point they're complaining that it has to be published to one person. They actually were suggesting that at one point that it should be in New York because that's where she sent it first. So ACL was the first to see it. Well, they co-authored it to a certain extent, except for the specifics that she put in that referenced or implicated Depp. This is my remembrance of the pretrial hearings. Because of this error, Heard suffered a substantial prejudice in two ways. First, and most significantly, Heard was unable to subpoena any witness for the 6-week trial and was forced to rely almost exclusively on deposition designations to defend herself. Thank you, Chris. Okay, so this point is that if you live outside of 100 miles, you can't compel a witness to come and testify live in court. Now, the court did make availability to them live link testimony, and Mr. Depp took advantage of that quite a bit. Ms. Heard, I think, did with a couple of her new non-personal witnesses. Heard was unable to subpoena any witnesses for the 6-week trial and was forced to rely almost exclusively on deposition designations to defend herself. Forum nonconvenience considerations include availability of compulsory process for attending of unwilling witnesses. Okay, those would be her friends, by the way. Those would be her friends. Those would be what Adam Waldman referred to as the cohorts, right? Thank you, Twisted Tiara. Not a lot, hon, but I totally appreciate the time you put into it. Everything helps. Everything helps. Thank you so very much. Thank you so very much. Yeah. The unwilling witnesses are her friends, the cohorts. They refuse to come testify live. Describing the presentation of deposition testimony at trial as a less desirable procedure which deprives the trial judge and jury of the ability to evaluate the witnesses in person. That's true, but at least they were on video. The lack of compulsory process meant, first, that the only live fact witness Heard was able to call in her defense was her own sister. They had live link available. Depp, who has considerable resources from his decades as a movie star, was able to call more than 15 live fact witnesses who voluntarily traveled to Virginia from another jurisdiction or appeared by WebEx, many of whom are employed by or otherwise financially linked to Depp. Oh, give me a break. Yeah. She had the same availability of the WebEx. Somebody could have just gone to a law office in California where they lived, which is what they were willing to do or they were compelled to do in the UK. Depp capitalized on that disparity, arguing to the jury, you may have noticed that no one showed up for Miss Heard in this courtroom other than her sister, other than a witness who traveled to Virginia as her paid expert. This is a woman who burns bridges. Her close friends don't show up for her. 100%. 100%. Thank you, Rhonda. Can't figure out how to make it an even. Oh, no, this is amazing. Thank you so much. Appreciate it. No one showed up for Miss Heard in this courtroom. That includes the web link. That live web link is the same as showing up in court. Kate Moss, not at Johnny's cost, said, hey, I need to talk. Can I talk to y'all? Let's set this record straight here. Second, the lack of compulsory process prevented Heard from responding as Depp shifted his case. While Depp was able to redirect witnesses and call new, previously undisclosed witnesses in rebuttal, Heard was reliant on video deposition testimony. Well, I'm sorry, nobody wanted to jump to help you, Amber. You know, like the randos that jumped to help Johnny. This is precisely the kind of disadvantage the doctrine of forum nonconvenience was designed to prevent. The trial court abused its discretion in denying Heard's motion to dismiss, and this court should now reverse and dismiss this action without prejudice. So this is the argument, guys. We're now into the meat. In fact, they used Josh Drew's deposition from 2019, like they didn't even attempt to get him a new one. The trial court should have dismissed Depp's claims because the challenge statements are non-actionable expressions of opinion. Expressions of opinion are constitutionally protected and not actionable as defamation. Statements that lack a provably false actual connotation or a relative in nature and depend largely upon the speaker's viewpoint are expressions of opinion. Provably false, factually connotation. Well, the jury certainly proved them to be false. Johnny, testimony, all of it was presented on a relative in nature and depend largely upon the speaker's viewpoint. Well, she's the only one that knew what was going on. I mean, it's he said, she said. This isn't like another reporter saying, I took a TRO and decided to report on it. Thank you, Liz. I so appreciate it. Whether a statement is an expression of opinion is a question of law. That is reviewed de novo. So they're asking the judge to relook at that whole part of it as brand new. But as far as the opinion is a question of law, was not her opinion that she suffered abuse by Johnny Depp. It's not her opinion that she was a DV, because something had to have happened. I mean, she's the first person writing this that she knew whether it did or didn't happen. And Johnny said, hey, it didn't happen. Oh, there you go. Brandon McCullough posted on Facebook. He was happy he wasn't needed as a witness after all. So he was ready to give his witness statement, but they decided not to call him. Oh, he posted that he was ready to go to Virginia because he lived there before and he was looking forward to a reunion of some kind. So he was ready to go. The 3 challenge statements, with the exception of the portion of the headline stating I spoke up against sexual violence, which obviously is true, are protected opinion. There is no which is obviously true. So now, okay. First they don't want to associate it to her. Now they're saying it's true. Our protected opinion. There is no objective basis for assessing the truth or falsity of whether Hurt felt or faced our culture's wrath, whether she is a public figure representing DA, TV, or whether she saw institutions protect men. These statements are relative in nature and reflect Heard's subjective viewpoints. The trial court violated its essential gatekeeping function by allowing the jury to consider these non-actionable opinion statements. They showed several articles 2 years ago I spoke up about, and all the headlines were Amber Heard wrote an op-ed about Johnny Depp. So a lot of reasonable people believed this article was about Johnny Depp. This article is about she is a figure representing DV because it happened to her. That's what that op-ed was representing to the reasonable reader. This happened to me, and that's why I have these opinions. And Johnny Depp said, no, you're republishing this. It did not happen to you because I did not do that. That means your opinion is based on falsity, and you should not be put up on a pedestal. I don't remember anyone protecting Johnny at all. No, he was like behind the Iron Curtain immediately. The trial court should have dismissed. Oh, by the way, what I liked best about the experts, I can't remember his name. I can see him in front of me. His opinion was that in his years in the business, this op-ed was a call to action. Stop hiring Johnny Depp. That's what he testified. This was a call to action. And 3 days later, Disney said, we're going to go in a different direction. And in the op-ed, she even talks about, imagine a ship that's sinking and everybody wants to plug the hole and not go down with the ship. To me, that was like a straight call out to Disney and Pirates of the Caribbean. But that was my personal reading of the op-ed. When a defamation, the trial court should have dismissed Depp's claim because the challenge statements are not reasonably capable of conveying a defamatory implication as a matter of law. When a defamation claim is based on the allegation that an otherwise non-actionable statement conveys an actionable implication, the alleged implication must be reasonably drawn from the words actually used. A plaintiff may plead innuendo to show how the words used are defamatory and how they relate to the plaintiff, but innuendo cannot introduce new matter, nor extend the meaning of the words used or make certain which is in fact uncertain. 2 years ago, that's pretty certain. What happened 2 years ago? Right? What happened 2 years ago? She accused her ex-husband of abuse. That's the only thing that happened 2 years ago. She didn't accuse anybody else. Of course, it came out that she was accused and arrested. So, which is in fact uncertain. I think it's pretty certain that everybody reasonably who read that said, oh, she wrote an op-ed about when Johnny Depp abused her. He's being treated as guilty instead of innocent when nothing had happened. They had not gone to court. She had just dropped it. It is not the providence of an innuendo to enlarge the meaning of the alleged slanderous words. Its use is to explain matters already expressly alleged. Whether a statement is reasonably capable of a defamatory meaning ascribed to it by innuendo is a question of law reviewed de novo. So they want another fresh look at it. Yeah, 2 years ago, this happened to me, and I made sure the world knew about it, not just in a TRO, but in the People magazine. I did an entire spread, photos and everything. I told them all these horrible things Johnny did to me. So even if they didn't notice or see reports of a TRO, they sure as hell saw the People magazine that was left in every doctor's office that I went to. Whew. It is undisputed that the op-ed does not mention Depp's name or the party's prior relationship, describe the 2016 restraining order, or discuss her statements or evidence in that proceeding. Rather, the op-ed advocates for changes to laws and rules and social norms regarding domestic violence and sexual assault so that women who come forward to talk about violence receive more support. Well, yeah, that's the part the ACLU wrote. She's the one who wrote the part 2 years ago. This happened to me. And Johnny finally had enough and said, it did not happen to you. You lied. I didn't do this. Notwithstanding the absence of any express reference to the allegations underlying the 2016 proceeding, Depp's position, as the op-ed implies, he abused her because reasonable readers would understand the words, 2 years ago, I became a public figure representing DA, to refer that proceeding. Duh. Depp contends, in other words, that Heard revived her 2016 allegations simply by describing in the op-ed the public backlash she faced after obtaining the restraining order. Yeah. Nobody thought anybody else. Depp's theory of liability extends the meaning of the words used beyond recognition. No, everybody knew she was talking about Johnny. The reasoning in Fairfax, etc., is illustrative. There, the court considered whether the host of a television news program defamed former Lieutenant Governor Justin Fairfax while interviewing two women who had accused Fairfax of sexual assault. The court concluded that Fairfax had failed to plead defamation by implication because the hosts had not stated that Fairfax did in fact commit the alleged sexual assaults, and the challenge commentary did not ascribe to any particular view of the underlying events, but rather focused on how persons who believe they are victims of SA are affected. So now it comes down to, does it matter if they really did it as long as they believed they did it? But in here it says they had not stated that Fairfax did in fact, so he was guilty, did in fact commit the alleged assaults. There was no trial back in 2016, remember. She just took the money and dropped her claim. So Johnny never had a chance to defend it. Similarly, in the op-ed, Heard did not recount the events underlying the DV proceeding. Rather, she discussed how women who alleged DV are treated by society, and she advocated for changes to relevant laws and social norms. To accept, as the trial court did, Depp's assertion that a reasonable reader could understand the op-ed to imply that he abused her merely by describing the public reaction to her allegations. No, because she said, I became a DV representative because 2 years ago I made claims against my husband, which he says now are false. Not he said them now, then too, but he's saying, you're reminding everybody, you're reprinting to everybody that I did this to you and I didn't. Would be to create a rule preventing any abused person from addressing the societal implications of speaking out about abuse. No, it's preventing anyone who lies about abuse. Not about an actual abused person. It's about lying about it. If that were the law, then it would be actionable in defamation to say 4 years ago, Christine Blasey Ford became a public figure representing sexual assault. That's plainly not the law. Help me. Yeah, the order was real, but the accusation was not. agent, her case is one-sided. She accused Johnny everything that she was guilty of. I need a drink. Tea. This would prevent any abused person. No. Don't lie. That's defamation. That's defamation. The trials court ruling also contravenes the doctrine of judicial privilege. The statements heard made in the course of obtaining the restraining order were absolutely privileged. Yes, we know that. And why is that important? Because this call to action they were making in the amicus briefs about this will prevent actual victims from speaking out because they'll be sued with defamation. No. Follow your restraining orders. Go to the police. You cannot be charged for defamation if it's true. But she went beyond the TRO and did the people spread. More people saw the people spread and the photos on the front cover than anything about the TRO. Permitting a claim for defamation by implication premised on a person's published statement about her experience in the aftermath of a judicial proceeding would substantially undercut the public policy served by the judicial privilege. Then she shouldn't have gone to the press. Keep it in the legal system. Don't go to the press. In overruling Heard's demur on this issue, the trial court relied primarily on Pendleton v. Newsom. We know that's the one, sadly, about the family who lost their daughter. The mother went to the school and said, hey, my child has terrible, I think it was peanut allergies. I want you to be aware of it. I want you to make sure you have EpiPens. I want you to know how to do this. And they were like, hey, we got this. Don't worry about this. We got it. And sadly, there was an allergic reaction and there was no EpiPen available. They then, without naming the mother, tried to say, hey, it's not our fault if parents aren't making sure we have what we need. It was clearly that they were suggesting against the mother. The mother sued. She won. A defamation action brought by the mother of a student who died at school from a peanut allergy. The mother alleged the school officials had made statements to the public and the press in response to the incident, implying she was to blame for her child's death. For example, an official said that the school's trained professionals can only be effective if a parent provides information, doctor prescribed health plans, and the medicines necessary to carry out those plans. Unfortunately, this not always occur. The Supreme Court held that these statements were reasonably capable of conveying the defamatory implication of the mother alleged. Did they file those embarrassing amicus briefs? Yes, they did file them. From what I saw, they're exactly what we saw. I didn't see any motions attached to them. So, unlike here, the statements at Ishel and Pendleton were in direct response to questions about the child's death and asserted that a parent's failure to communicate key information about an allergy impedes treatment of allergic reactions. Thus, the words used by the defendants readily implied a causal relationship between the child's death and her mother's actions. In stark contrast, the op-ed does not refer to Depp or say anything about Heard's abuse allegations or the judicial proceedings in which she obtained the restraining order. 2 years ago, I became representative of DV. I saw firsthand. The trial court improperly allowed Depp to use innuendo to enlarge the meaning of the alleged slanderous words. Everybody knew. Every article was reporting it. Amber Heard wrote an op-ed about Johnny Depp's abuse. They all wrote it. Post-trial motions Heard made and the trial court erroneously rejected a related point. The trial court should have held that a plaintiff cannot recover for defamation by implication where the alleged implication is based on statements that are true on their face, and involved a public figure of a matter of public concern. So the fact that she acquired the TRO makes it true on their face, I guess is their claim. And because it's a public figure, he just has to lay down and take it and have his reputation destroyed. And there's nothing he can do about it. 2 years ago, she got a TRO. 2 years ago, she, according to this jury, falsely got a TRO because Johnny said he did not do this. They went through the trial and the jury agreed. She lied. As I lay here under my JD blanket so much, I'd love to say, but just want to say thank you all for what you do for us. You're so welcome. Thank you for the super chat. Statements that are true on their face. Yes, she got a TRO because she claimed her husband abused her. He said he didn't. She republicated those. And because he's a public figure, he's just supposed to lay down and get destroyed. That's my understanding. Defamation by implication or innuendo is actionable only if the statements regard a private individual and private affairs. This is the law they are seeking to push through Virginia. It is not from Virginia as I understand it. Statement about public figures that is true on its face cannot support claim for defamation by implication. It's just because she got a temporary restraining order. Remember, I don't know what happened to innocent before guilty. A temporary restraining order doesn't make you guilty. You have to go for the second part of it, and she dropped it. So just because she made claims, those claims were not true on its face, only that she made the claims. And he said, no, I didn't do this to you. Courts in other states have similarly limited claims for defamation by implication by a public figure where the defamatory inference arises from the omission of material facts in the challenged. So further, the public interest in speech on matters of public concern, including speech about how segments of the public react after someone makes allegations of abuse, and hold that Depp failed to prove defamation by implication because he did not prove that the statements are false on their face. Can we rewrite that and see if we still agree? Including speech on how segments of the public react when someone makes false allegations of abuse. Would we react differently now that we know after the trial? So it's okay now that everyone can make false allegations against people of public people, and they just have to take it? Ensuring that defamation suits proceed upon only statements which actually may defame a plaintiff, rather than those which merely may inflame a jury to an award of damages, is an essential gatekeeping function of the court. The trial court failed to fulfill this role, and this court should reverse and dismiss the claims because Depp cannot make a claim for defamation by implication as a matter of law. See, they don't want a retrial. They just want this erased. It never happened. 2 years ago, I became. And the judge felt, not just one judge, too, because I think Judge White initially ruled on this, the demurrer with Kaplan. I can't remember. Judge Ascarati obviously ruled on it in the summary judgment and to dismiss it after case in chief. The trial court should have dismissed Depp's claims because the doctrine of issue preclusion prevents relitigation of the UK courts, ruling that Heard's abuse accusations are substantially true. Issue preclusion bars successive litigation of an issue of fact or law actually litigated and resolved in a valid court determination essential to the prior judgment, even if the issue recurs in the context of a different claim. The public policy underlying the doctrine is to relieve parties of the cost and vexation of multiple lawsuits, conserve judicial resources, and by preventing inconsistent decisions, encourage reliance on adjudication. Put differently, one adverse litigative adventure on any one issue is enough for one litigant. Judge Ascarati did a beautiful write-up on her reasoning and opinion. It made it very clear that different judge, different judicial system, one judge versus a jury, different country, different discovery rules, that Amber Heard didn't have to be compelled to provide anything, on and on and on, different article, different parties. She was not a party. She cannot, if, for example, if, let's say, and this is important, let's say the NGN lost and they had to pay $50 million. Amber Heard wasn't going to have to pay any part of that money. So she was not the same as NGN. To establish issue preclusion, a party must show that the relevant factual issue was actually litigated in the prior proceeding. Well, it wasn't because it was a different article. That it was essential to the prior judgment and that the prior proceeding resulted in a valid final judgment against the party against whom the doctrine is sought to be applied. In certain circumstances, the party asserting issue preclusion also must show mutuality, that the parties to the two proceedings are the same or in privity. Well, they're not. I just explained that. If NGN had lost, you sure as hell Amber Heard would not have been paying toward the damages. The Virginia Supreme Court has recognized that the mutuality doctrine should not be mechanistically applied when it is compellingly clear that the prior record that the party in the subsequent civil action against whom collateral estoppel is asserted has fully and fairly litigated and lost an issue of fact which was essential to the prior judgment. Nope, not fully and fairly, because Amber Heard was in a different position and was not compelled to provide evidence. Cannot wait for Ben's response. She admitted more than once on the op-ed was about him. Yeah, I'm really curious about the LawTubers' response. My biggest question is, when they are now arguing pre-trial stuff, can they consider anything that came out at trial? I'm guessing not. I'm guessing everything's going to be on what happened in this moment in time with this judge's ruling. Forget the trial ever happened. Yeah, I will provide it as soon as I'm done, I'll put it in the description. Traditional rationale for mutuality does not apply when issue preclusion is asserted defensively. That is, when the defendant, a stranger to the prior proceeding, attempts to preclude the plaintiff, a party to the former proceeding, from relitigating an issue plaintiff lost in the earlier case. Where the plaintiff has already had his day in court with the opportunity to produce his witnesses to examine and cross-examine the witnesses for the other side. Boy, I would love to do a video to compare and contrast how completely different it is and how you don't get a rebuttal section, and how your examination is specifically limited not just to the witness statements, to what, for example, Laws representing NGN, she questioned witnesses, and if she did not bring up something that was in the witness statement, Sherburne wasn't allowed to. It's a very, very different system. Witnesses from the other side and to appeal from the judgment, there is no sound reason to allow him to have a second bite of the apple. Oh, yes, there was. And Judge Ascarati stood so strongly against the interlocutory appeal. She said no. Whether an issue is precluded by a prior judgment is a question of law for the appellate court to decide de novo. Fresh look. The UK judgment meets all the requirements for non-mutual defensive issue preclusions against Depp, yet the trial court erroneously required mutuality. She was not a party in that case. She was not governed by the same rules as NGN. She's not governed by the same discovery rules here in the US. And Judge Ascarati implicitly said, we hold our choice of jury to highest esteem versus a single judge. There is no dispute that the truth of Heard's abuse allegations was actually litigated and essential to the prior judgment. The Sun published an article calling Depp a wife beater, and Depp sued the Sun, alleging that it defamed him because the abuse allegations were false. In rejecting Depp's claim, the UK court found, based on much of the same evidence presented in this course, which the jury didn't agree. That's for sure. The jury was interested in the police testimony for sure. They didn't just throw it out because, oh, you didn't take notes. The jury was definitely interested in the audio and didn't consider it out of court statements. Except, when they only considered the one video that Amber submitted about the headbutt. That Depp had engaged in at least 12 acts of domestic violence against Heard, causing her to fear for her life. The court found at the civil level, at the UK civil level, the UK court therefore concluded that the defendants had proved the Sun's description of Depp as a wife beater was substantially true. Not clear and convincing level here in the US. There's no question that Depp had a full and fair opportunity to litigate this issue. Depp chose to file the libel suit in the UK, predicated on the same allegations that he contends were revived by Heard's op-ed. Indeed, Depp's UK counsel asserted prior to trial that his client could only be vindicated by a clear and reasonable judgment from the UK court. At that time, they had no idea if the Virginia court was going to even happen. Parties can settle. The parties to the UK proceeding engaged in extensive discovery and motions practice, and Depp had also had access to this discovery conducted in this case for 16 months prior to the UK trial. He didn't have access if it was marked confidential. No. So, there's it. Is that my link, Squirrel? Okay, so someone else posted it up because I also have a Dr. George link. Under the UK law, Depp faced a much lighter burden of proof on his claims than he did in Virginia. In the UK, the defendants bore the burden of proving the substantial truth of the statements rather than Depp having the burden to prove them false. Yet Depp still lost and then exhausted his appeals. He wasn't denied. I don't think that's fair statement. He was not granted permission. He was denied. In short, Depp had his day in court in the UK proceeding, and he should have been precluded from relitigating the exact same factual issue. It was not the same. Different article, different parties. Amber Heard is being assessed at, required to provide discovery. Decided against him in the action. Accordingly, this court should reverse it and dismiss Depp's claim. So again, we're going for dismissal. We're not going for retrial. So they wanted dismissed for inconvenience location and said without prejudice, so he could file it in California he wanted if they went that route. But otherwise, so far, they wanted dismissed and no chance of relitigating. The trial court erred in denying Heard's motion to set aside the jury's verdict based on Depp's failure to prove actual malice. Well, they said she knowingly lied. She knew that Depp didn't abuse her. Therefore, she knowingly lied when she claimed herself 2 years ago to be a representative of DV because she lied and she wasn't a representative. Let's see. Both under the First Amendment and as a matter of Virginia state law, Depp, as a public figure challenging statements to the public on a matter of public concern, was required to prove by clear and convincing evidence that Heard made each of the challenged statements with actual malice. Actual malice is a term of art that means that the defendant either knew her statement was false, well, that's what the jury said at the time she published it, or published it with reckless disregard as to the truth. That she subjectively entertained seriously doubt regarding its truth, but published it anyway. Well, I think they decided that she knew her statement was false, that she was lying. In defamation by implication cases such as this one, establishing actual malice requires making a second showing. Not only was Depp required to show knowledge of or recklessness in regard to the falsity of the statement's defamatory meaning, he also was required to demonstrate that either the defendant intended to communicate the defamatory meaning, I was a victim, or knew the defamatory meaning and was reckless to disregard it. Her entire premise in the op-ed was that she was a victim of domestic violence 2 years ago, which everybody knew could only have been at the hands of Mr. Depp. The trial court also erred in holding that Heard was not in privity with the Sun with respect to the factual issue of the truth of her allegations. Privity exists where a party's interest is so identical with another. Again, it's not that identical because she would have, if it had gone the other way, she wouldn't have been claiming this. Oh. Without this requirement, a defendant could be held liable for what was not intended to be said, which would eviscerate the First Amendment protections. Does anybody here think that Amber Heard did not intend the audience to understand that she was an actual victim of abuse 2 years ago? The defendant could be held liable for what was not intended to be said. To any reasonable reader, were you expected to understand that she was, in fact, a victim? And it happened 2 years ago. Simply because a statement reasonably can be read to contain a defamatory inference doesn't mean that the publisher of the statement either intended the statement to contain such a defamatory implication or even knew that the readers could reasonably interpret the statements to contain the defamatory implication. Same question. Did anybody of you, when you read this, did any of you think that Amber Heard was not suggesting that she was an actual victim of abuse 2 years ago when it was made very clear that she made public accusations against Depp? Do you think she was writing this just because this is how other people who have been actual victims were treated? Not that I'm claiming to be an actual victim 2 years ago. Is that how a reasonable reader would take it? Burden of probability, the UK was different because the burden of proof is on the defendant and not the applicant. And I hate when they try to do this. And I think the instance of probability was 51% versus 49% more likely. We're here as a public figure. It was clear and convincing, not without doubt. only Miss Heard knew what happened to her. She made these statements. She wrote this op-ed to tell the world, this is what happened to me because I experienced this, because I claimed against Johnny Depp 2 years ago. Yeah, and that's my question for the lawyers. All this came out in trial. We're still at the pre-trial motions. I'm sorry, I didn't mean to click that so early. The emails and all of that. Yeah, it all came out in the trial. Thank you so much, Heather. I so appreciate it. They seem to forget she was only a witness. She didn't win anything. She was only a witness. Not only did she win anything, she wouldn't have lost anything. She was only a witness, so she was not compelled. I was in that hearing and I read the order. I deny compel her this. I deny to compel her this. It was over and over and over that Johnny was asking her to provide stuff. And then when she did hand over stuff from Virginia that was marked confidential, Johnny had to agree not to bring sanctions against her. So when they say that he had access to all the same discovery, he didn't. He would have been defaulted in Virginia if he released anything that was marked confidential. Okay. Whether the trial record is sufficient to support a finding of actual malice is a question of law. And this court must make an independent review of the record. Judges must independently decide whether the evidence is sufficient to cross the constitutional threshold that bars the entry of any judgment that is not supported by clear and convincing proof of actual malice. Well, now we're back into the trial. The jury heard it all. They were convinced it was actual malice. Significantly, in deciding this issue, this court must evaluate the record in light of Depp's burden to prove that two prongs of actual malice by clear and convincing evidence. Depp failed to meet the burden, and therefore this court should reverse and enter judgment for Heard. The jury heard it all. Both sides had a chance. They presented it, and yeah, at that time she said, I wrote it about him. I mean, if they're saying now that the jury wasn't able to meet find for the definition of actual malice, now we're back into the jury. But this is supposed to be prevented. Depp failed to prove by clear and convincing evidence that Heard was aware of and intended to communicate the alleged defamatory implications. A person cannot knowingly or recklessly tell a falsehood if she did not intend to and was not aware that the words she used would be understood to communicate such a falsehood. The evidence at trial fell far short of establishing by clear and convincing evidence that Heard had the communicative intent to accuse Depp of domestic abuse in the op-ed. I'm just shaking my head at this one. She was not able to understand that what she was saying 2 years ago, reference to all the claims she made publicly with this big people spread, remember, to accuse Depp of domestic abuse in her op-ed. The undisputed evidence showed that the ACLU proposed that Heard author an op-ed on the ways in which survivors of gender-based violence have been made less safe under the former presidential administration. The ACLU then prepared the initial draft of the op-ed. Heard engaged her attorneys and, based on their advice, made significant efforts to remove all references to Depp and their marriage from the draft. As Heard explained, the purpose of the op-ed was not to discuss Depp or the particular allegations she raised in 2016. That's not what I remember. I remember in the earlier emails, it was all about getting something in there about Depp, and it was her attorney saying, you need to pull back, because she wanted to say, when I got a TRO against my ex-husband. And the ACLU absolutely wanted Depp in there. But rather to discuss what happened to her in the public arena after she spoke up. And in sum, Depp presented no evidence, much less clear and convincing evidence that Heard either intended to communicate through the op-ed that Depp had abused her or knew of the defamatory meaning and was reckless in regard to it. Indeed, just the opposite was true. What? On this basis alone, the jury's verdict cannot stay. I'm choking on this a bit. I'm seriously choking on this a bit. Okay, so what I just read is, I understand it. The judge made it very clear that it would be a matter of fact finders if she was implicating Johnny Depp in the op-ed. It was up to the jury to decide that. It was up to the jury to decide from the testimony if she might have been lying. But it wasn't up to the judge to decide whether or not this was a matter of law. And that's what they're arguing. And I remember that. They were saying, no, The jury's the fact finder. They will decide how a reasonable person would read this op-ed, not as a judge, a reasonable person. And for her to say it wasn't intended to communicate through the op-ed that Depp had abused her, well, she certainly said 2 years ago, I became the poster child for it because she claimed it. And he's saying, you just brought it up again. We agreed not to talk about this anymore. We agreed to move on our separate ways. And the only way people would take this seriously as you being a representative of DV is because you made those claims against me. That's my understanding as a reasonable reader of the op-ed. Knew the defamatory meeting was reckless in regard to it. Well, she knows she lied or didn't lie. Jury said she lied. Depp failed to prove by clear and convincing evidence that Heard either knew the allegations implication that he had abused her was false or subjectively entertained serious doubts about its truth. Even if this court concludes that the record contained clear and convincing evidence that Heard knew at the time of publication that the op-ed communicated to readers the implication that she was asserting that Depp had abused her. Yep. The record contains no evidence that she knew or thought it likely that such a statement was false. Well, that's what Depp proved at trial. Depp failed to carry his burden on actual malice for this separate reason. Additionally, while Depp argued the op-ed referenced the day Heard obtained the restraining order by stating she became a public figure 2 years ago, he failed to prove any implication that he abused her was reasonably drawn from the words actually used. I think, okay. In this regard, it bears emphasis. There is a significant difference between proof of actual malice and mere proof of falsity. Depp cannot prevail merely by proving that the abuse did not occur. Rather, to establish actual malice by clear and convincing evidence, he was required to offer affirmative evidence that Heard did not believe he had abused her or entertained serious doubts about whether he had done so. So this is the caveat. Okay, so he proved that she didn't abuse her, but she kind of thought she was abused. There is no such evidence. Depp alleged that the op-ed falsely implied that Heard was a victim of domestic abuse by him. Trial court's identification of alleged defamatory meeting as Mr. Depp abused Ms. Heard. Because actual malice is a subjective standard, whether Heard believed Depp abused her must be judged by her own state of mind. Well, people, a reasonable reader of this op-ed associated to Johnny Depp, mostly because of her People magazine, where she spelled out the physicality of the abuse. Not just, he said bad words to me. He told me I had a fat ass. No. She spelled out the physicality of her claims, both in her TRO, but also reiterated with photos in the People magazine, the photos that were questioned during the trial. So now it's a subjective standard whether Heard believed Depp abused her must be judged by her own state of mind. That's not what was told to the public. Heard testified unequivocally that she believed Depp had abused her physically, verbally, emotionally, and psychologically. Depp and his expert witness conceded that abuse can take many forms, including verbal, emotional, and psychological, and the trial record contains considerable undisputed evidence supporting the proposition that Heard at the time of publication believed that Depp had abused her. So again, we're going to remove all the physicality apparently now that she claimed in the People magazine with photos and whatnot. And we're supposed to believe now she only, in her mind, believed. Depp demanded that Heard cut him with a knife, threatened to cut himself in her presence when she refused to comply. Yeah, he was basically saying, you lured me here to put our marriage back together. Now I find out you still want the divorce, but you want to possibly work on a reconciliation. And then I come back and find out that, no, you're just trying to get me to admit to, these are the texts between him and Carino, that you lied and that I lied and I did not lie. You might as well cut my heart out. I'm dead. You've destroyed me. Depp engaged in violent behavior in Heard's vicinity on multiple occasions, including kicking cabinets, doors, smashing glasses, punching a light fixture, and toppling racks of clothes in her closet and throwing one rack down the stairs. Okay, as far as the kitchen, he stopped when she walked in. He didn't know she was there. She was standing in the door getting her camera ready. He was obviously upset. He had no idea she was in the room at the time. Smashing glasses, I don't know about that. punching a light fixture. Yeah, he was leaving a room and he shot his hand up apparently and knocked a light fixture. And as far as throwing racks down the staircase, she was not in the room. She was in another room. She was not, so it was not in front of her. She was in another room with her sister. Depp exhibited jealous and controlling behavior toward her, such as accusing her of infidelity and promiscuity, including in messages written around the house with his own blood and forbidding her to acting in movies or having meetings. As far as the having meetings, no, it was supposed to be that we had come to agreement how these things would be organized with our calendar and whatnot. We would work together, things like that. Forbidding her from acting in movies. Let's just talk about, he didn't forbid her. He told her, this isn't a good idea. You want my advice from being in this? Don't do London Fields. You know, I got you a test for Fantastic Beasts. But if you're going to continue to do these kind of movies, this is the kind of roles you're going to continue to be cast in. Jealous and controlling behavior. Well, we've seen the elevator footage. Depp admitted to headbutting her though he claimed it was unintentional. That transcript, as they will show, says first I get excited about this. At first she texted Raquel soon after it happened that Johnny said it was only a little knock on the head. And that's what he tested. So I didn't even consider putting it in my witness statement because it was an accidental knock of the head. She was clawing at me and kicking me, and I bear hugged her to try to calm her down, and we knocked heads. But in August, when they had met in San Francisco and she was badgering him with you here on the audios, she said, you headbutted me. He goes, I didn't in the nose. He goes, I didn't headbutt you in the nose. I headbutted you in the head. That's not the same thing. I didn't break a nose. And she said, to the best of my recollection, with pulling it up, I couldn't believe you had done that. Well, if this is a man who she claims has been abusing her for so long, why would she be in shock that he would knock heads with her? Number one. And two, she said, I didn't think you meant to do it. I didn't think you knew you had, which pretty much matches what Johnny had said, that we just bumped heads. It was accidental. It wasn't intentional. But Heard's testimony was completely different in the UK, where he was intentional, put his fist at his side, reared back, and hit her on the face as hard as he could with his nose, which is not what the full audio says. It was unintentional. The record also contains many other examples of disputed evidence of abuse, but the court need not even consider those to appropriately conclude the trial court should have struck the jury verdict for Depp's failure to prove actual malice. So there's a lot of disputed evidence, but we won't consider that. Like the LAPD showing up not once but twice with body cams, like the medical doctors that said they didn't see any bruises or anything. Depp told her on one occasion, I left last night, honestly, I swear to you, because I just couldn't take the idea of more physicality, more physical abuse on each other. Yeah. She's throwing things at him. And at some point, you're going to throw something back. He says, I'm walking away. I'm not going to be put in a position where you're going to incite me so much that, I might finally pop the wife. So he left. Same as I would never spray my anger on the one I love. Importantly, even if the jury could properly have concluded that these undisputed facts did not constitute abuse, and a reasonable jury could not have done so, so now this jury's unreasonable, Depp presented no evidence that undercut Heard's testimony that she believed this conduct amounted to abuse. Consequently, Depp failed to meet his burden on the second prong of actual malice, and the court should enter judgment in Heard's favor for this independent reason. As far as the kitchen cabinet, she was just lounging there with a cup of coffee going, really, I thought we were fine. I mean, she wasn't scared. I mean, if this is a man who abused her all the time, she stood there as a target and was not concerned at all. So she showed no signs of fear in that kitchen video. And again, she wasn't present for the other things. Controlling jealous, we've seen the videos. The trial court erred in failing to grant a new trial for multiple reasons. So now we're getting into the new trial issues. First, they want it all dismissed. If you're not going to put it in California, if you're not going to dismiss it entirely, here's why we should at least get a new trial. So they are throwing everything at the appeal judges. For each of the several independent reasons set forth above, this court should reverse the judgment in favor of Depp and either enter judgment in favor of Heard or dismiss Depp's claims without prejudice, meaning you go to California. If, however, this court disagrees with all the foregoing, then at minimum, the court should reverse and remand for a new trial, again with multiple independent reasons. The trial court made numerous evidentiary errors that severely prejudiced Heard at trial. And I've heard from all the law tubers, they do not like evidentiary issues in appeal. This court reviews a trial court's admission or exclusion of evidence for abuse or discretion. The trial court's numerous erroneous evidentiary rulings prevented the jury from receiving evidence highly probative of the truth of the implication Depp alleged, the op-ed conveyed, and of Heard's lack of actual malice, while also permitting the jury to receive irrelevant and unduly prejudicial evidence used by Depp to attack Heard on a purely collateral matters. Each of these evidentiary errors standing alone would warrant a new trial, and considering cumulatively clearly mandate reversal. Explaining two or more of the individually harmless errors have potential to prejudice defendant to same extent as single reversible error if multiple errors so fatally infect trial as to violate fundamental fairness. The trial court erred by excluding evidence of Depp's abuse on Heard's state of mind. Long before Heard sought a restraining order in 2016, Heard made numerous contemporaneous statements to third parties about Depp's abusive conduct. Instead of permitting the jury to consider this critical evidence, the court excluded it based on an erroneous application of Virginia's hearsay law. Statements about Depp's abuse made years prior to any potential litigation were essential to the jury's consideration of the facts and Heard's credibility, especially given that Depp made Heard's credibility the linchpin of the case. I think Dr. Hughes brought all of that out. All of it. Heard's reports of abuse to medical providers plainly were admissible. From 2011 to 2016, Heard sought treatment from several medical professionals as a result of her volatile and violent relationship with Depp. Now, these medical providers, my understanding, are psychiatrists or therapists. I'm not even sure they're psychologists. A number of these professionals documented Heard's contemporaneous statements about Heard's abuse in medical records. The trial court, however, excluded this evidence as hearsay, which Depp then used as both a shield and a sword. Not only did Depp convince the court to preclude Heard from presenting relevant admissible evidence to corroborate her claims, but Depp then weaponized that exclusion, arguing to the jury that such evidence did not exist. Ms. Heard has told you that she has mountains of evidence of abuse, but there are no medical records reflecting she sustained any injuries from the abuse she claims. That statement is unequivocally false. The trial court had wrongly excluded those very mountains of medical records. Now, there's a difference. They do define hearsay. Medical records are something that comes to a conclusion that can be treated like a broken arm. Her statements to her therapists were to benefit only herself. There was no way to treat her. There was no way to fix what she was saying. There's no way to diagnose it as truth or not. It's not her therapist's jobs to investigate and evaluate. So that's why they are hearsay, and they've always had been. They're statements that benefit only herself that can't be disputed because it's just her saying this happened to, this is how I felt and this happened to me. And it's not disputed because there's no medical test that can be done. But Dr. Hughes did speak on all that. Virginia's hearsay rule precludes introduction of an out-of-court statement offered to prove the truth of the matter, asserted only if the statement does not fall within one of the recognized exceptions to the rule. One exception is for the statements made for the purposes of, there it is, medical diagnosis or treatment. Medical and psychological records that included victim statements were properly admitted under this hearsay exception. In this case, the trial court should have admitted her statements to medical providers under this exception. Well, I think what's interesting is there are no medical records to back up the injuries she's claiming. Hey, you watching? Could you hit that like? Oh, thanks, Square. Oh, you didn't have to do that. I saw that. I appreciate you so much, but you did not have to do a super chat for that. Thank you, guys. Yes, please hit like, subscribe, check your notifications. All that happens. Yeah. She supposedly did see an ENT, but it was so far. Who did I just see that there? Yeah, she supposedly had seen an ENT, but it was so far after their divorce that there's no telling whether an injury could have happened recently, or maybe years ago if she had a nose job, or maybe years ago if she was doing cocaine. The trial court should have admitted Heard's statements to medical providers under this exception. Medical records are admissible under the business records exception to hearsay. And again, these are to be medical diagnosis or treatment. And that's where I think therapists are not recognized certainly not without testimony, where both sides can cross. Separately, the trial court should have admitted Heard's prior statements about Depp's abuse as non-hearsay assertions offered to prove Heard's state of mind. It is black letter law that statements admitted as evidence of an individual's state of mind are not hearsay. A statement that is offered to prove state of mind is not hearsay because it's not offered for its truth. Because of Depp's burden to prove actual malice, Heard's subjective state of mind regarding whether abuse occurred was a primary issue in the case. Thus, evidence that she subjectively believed she was a victim of abuse was critical. Finding error excluded statements were offered to show state of mind. We have these affirming admission of statements not offered for the truth, but to show defendant's state of mind. So although he was not abusing her, is this what they're suggesting? Because the jury found that there was no physicality, there's no medical physical evidence, but in her mind, because she was being abused, I guess, psychologically, they should have allowed this in. But again, her claims were definitely physical. The trial court also erred when it excluded a May 24, 2014 text exchange between Heard and her father in which Heard reported Depp's abusive conduct and asked for help. These messages were offered to show Heard's subjective belief that abuse had occurred. Additionally, the court erred by excluding Heard's statements to Catherine James in which Heard reported that Depp was worse than ever. Heard sought the omission of this text to show her state of mind and to impeach James' deposition testimony that Depp played in the trial. The trial court wrongly excluded it. Well, all right, let's take the first one. Any messages with her dad? Johnny Depp has a ton of messages from her dad saying how much they love him, even after her claims, after the TRO. And they are so sorry this is happening. This is both the mother and the father, but the mother passed away. They attempted to subpoena him. They attempted to have him give a deposition, and they were unable to. So for her now to say, I want to cherry pick one message that might suggest abuse, because it's the way she words things, I don't think she ever said that she was hit. So she wants this one text message in from her father without all the other messages her father sent, I would presume. Abusive conduct. As far as Kate James, he was worse than ever. What does that mean? He drank more? He wouldn't stay and talk with her? I mean, who knows what that means? And Kate James gave deposition testimony, and I guess they didn't bring it up. Here, the trial court improperly prevented the jury from considering several separate instances in which Heard reported Depp's abuse to medical professionals. Again, it looks like they're going to be all therapists. Heard, it's from 2011 to 2014, Heard was treated by clinical psychologist Bonnie Jacobs. Dr. Jacobs' contemporaneous medical notes show Heard repeatedly reported Depp's abuse. For example, August 2012, Heard reported Depp was in a rage, accused her of cheating and threw a glass by her head. September 2012, Heard reported Depp was violent and ripped her nightgown, threw her on a bed. Tried to have sex, but more angry. November 15, 2012, Heard reported sometimes Johnny becomes verbally or sexually abusive after spending time with her father. So these are all to her therapist. So this is her statements that are not investigated with no medical proof of diagnosis or treatable. And their hearsay. Bo Johan, thank you so very much. Really wish I could donate my extra pounds, but dollars will have to do. That is truly generous. Thank you so very much. And I appreciate all of you. I really do. So again, she's made these claims that could have been so blown out of proportion. Who knows? But the point is, she's making these claims to a therapist who's not diagnosing, who's not investigating, who can't do any medical checks to the veracity. And she didn't call Bonnie to testify, is my understanding. Any statements made for the sole benefit of yourself is hearsay that can't be corroborated. 2014-2016, Heard was treated by psychologist Connell Cowan. Dr. Cowan's records reflect that in December 2015, Heard reported that Depp was physically abusive and that he started the physicality pushing her down. That wasn't the testimony he gave, because he did testify. Heard sought treatment from nurse Erin Filati, who was Nurse Borum back then, for injuries caused by Depp. Filati's notes reflect that on December 16, 2015, Heard reported that Depp headbutted her. And on May 21st, 2016, Heard reported that Depp hit her in the face. Well, Ellen Filati gave testimony and said that, I don't remember her saying anybody called her about a concussion check, and that she did see Heard and could not see any of the bruises or injuries Heard claimed. So that's the difference between what Erin Filati saw and was able to diagnose and medically treat versus what she's just being told, my opinion. 2015-2016, Heard and Depp saw Laurel Anderson, a clinical psychologist who was treating them. During therapy sessions, Heard reported that Depp slapped her, hit her in the head, pulled her hair, and kicked her in the leg, causing her bruises. And again, Depp was not present at the time, so he could not agree or disagree with what she was saying or give further context. Although they did meet together at times, and she met with Depp separately. So she also asked if before this December 15th incident happened, apparently she reported some of these things. My understanding is what I remember, that this was reported to her on December 15th during the day before the incident happened. And then she further asked, should I report it to the police? Would that help me in my divorce? 2015-2016. Oh, by the way, and Laurel Anderson did testify to the jury that a few days later when she saw her, she had some minimal bruising. So the jury knew about that and still did not believe her. 2015-2016, Amy Banks, a clinical psychologist, treated Heard and Depp. In a joint session, Heard discussed Depp's violence, which he did not contradict. I disagree with that statement. That was not my interpretation of what it was read. It was read to me that there was discussion of violence, and he did not contradict. I think Johnny fully sat there thinking that because what she was saying was in a prior session, it had been discussed. And when it was brought up, Depp did not contradict. Well, I think Depp thought that Amber was admitting to violence. I mean, this was my interpretation sitting there in the courtroom listening to this. I got the impression it was Depp didn't deny violence had happened because he didn't do the violence. These statements, which were made long before Heard would have had any motive to fabricate allegations of abuse, each should have been admitted as statements made for the purpose of attaining medical treatment for both emotional distress and physical injuries, as well as statements showing Heard's state of mind. Well, that may play into the IME, as far as this emotional distress and stuff and her claim of PTSD, she put that on the table and that didn't go well for her. Moreover, each of these statements about Depp's abuse, whether made to medical professionals, family, or friends, also should have admitted for the independent reasons that they are prior consistent statements. This statement should have been admitted for the independent reason that it constitutes Depp's admission by silence. So they're talking about a declaration in presence of a party to cause becomes evidence has shown that the party at the hearing such a statement does not deny its truth. For if he is silent when he ought to have denied, then it's a presumption of acquiescence. And I still think the way it was presented that they talked about physicality and Depp didn't deny it because he wasn't the one that he thought the therapist was talking about. I mean, it was very muddled the way it was worded. Dr. Kipper and Dr. Lloyd, Heard's and Depp's physicians and nurse, also wrongfully were precluded from testifying that Depp worked himself up into a rage and tried to fight Heard while Depp was going through substance abuse withdrawal in August 2014. Heard also reported to Dr. Kipper that pushed her. Well, I think abuse has to be intentional. I'm not sure that if any of that happened, it would meet the levels of abuse. But again, we're not party to all that was argued. A prior statement that is consistent with the hearing testimony of the witness is admissible for the purpose of rehabilitating the witness's credibility. Ordinarily, proof of statements made by a witness out of court cannot be received to corroborate his testimony. But such statements may be admitted where the credibility of the witness has been assailed on the ground of his story is a recent fabrication or that he has some motive for testifying falsely. Once Depp attacked Heard's credibility and accused her of fabricating her allegations of abuse, the trial court should have permitted her to introduce those prior inconsistent statements. If not reversed, the trial court's exclusion of contemporaneous reports of domestic abuse to medical professionals will make it more difficult for other abuse victims to prove allegations of abuse and likely deter them from coming forward. Whoa. Hearsay rules. I mean, they would have to overturn all the hearsay rules on this one. I think this is crazy. But the bottom line is she made some horrific physical claims that were never supported by any medical doctor. She never sought medical treatments, that she had broken nose, broken ribs, or thought I had, or felt like I had. I mean, the story kept changing. I don't know. I've always postured, just an example based on what Curry said, Dr. Curry said and all, that when she first started dating Johnny, everybody fell in love with him. Everybody thought he was wonderful. And I think she became jealous. She's like, wait a minute, you're supposed to be my friends, my family. You're supposed to love me first. Things aren't so great, you know. And that would go into this borderline personality disorder, this histrionic personality disorder, after what I heard Dr. Curry testify to. So silence is not acquiescence, or else that could be the case in sexual assault and rape. And it's literally written in the California law that silence doesn't equal compliance. The court improperly excluded a text exchange in which Depp's agent is not his agent. That was ruled he's not his agent. His personal assistant, Stephen Deuters, corroborated Heard's allegations of abuse on a flight between Boston and Los Angeles. A statement by the party's agent, he's not an agent or employee, he wasn't acting in his role as an employee, made during the term of agency or employment concerning a matter within the scope of such agency or employment. It wasn't. It was ruled that he was not. He was acting as a friend between the two to just tell her whatever you need to tell her to calm her down, and let's get past this because she's not going to stop until someone talks to her. It is an exception to the hearsay rule. And this was part of the proffers, and I did this. They wanted Stephen Deuter's text in without his testimony. They wanted to say, look, he's acting as an agent and employee of Johnny when he made this text, and that's not true at all. And that's how the judge felt. Statement being made by an employee concerning a matter within the scope of his employment was reversible error. Those statements were not part of his job. He was acting as a friend, trying to smooth things over, trying to just say, look, I'll just do whatever I can to calm her down. Say anything that will appease her is not a job. On May 25th, Deuter sent a text message to Heard stating, when I told Depp he kicked you, he cried. Deuter sent Heard this message after Depp told Deuters to smooth whatever issue existed with Heard by texting Heard and telling her whatever she needs to hear. The trial court should have admitted this evidence as a party opponent admission because Deuters was an agent of Depp, and Depp specifically instructed Deuters to communicate with Heard regarding the altercation. Given Depp's attacks on Heard's credibility, this text message was critically important. I get that text message is very damaging, but Deuters had already testified in the UK saying, no, he did this as a friend. It wasn't part of his job. He was just trying to smooth things over, just trying to help them both out. That's not part of his job. And he said none of it happened. Now, remember, we also had testimony by other people on the plane that this did not happen. There were other witnesses that the jury considered. Prior to trial, Heard opposed Depp's motion in limine to exclude the UK judgment. Heard sought to omit the judgment after Depp opened the door to the evidence on numerous occasions. I had to wait for my opportunity to address the charges, and so today is my first opportunity when I've been able to speak about this case in full for the first time. When the trial court allowed references to the UK proceeding, it precluded the jury from learning about the outcome. Admitting the UK judgment would have been unfairly prejudicial to Depp, but its exclusion was unfairly prejudicial to Heard in at least two ways. First, the court's decision to allow Depp to refer to the UK proceeding without explaining the outcome left the jury with the mistaken impression that the outcome of trial was favorable to Depp, when in fact the UK trial court found that Depp had abused Heard in at least 12 different occasions. Depp promoted his misperception throughout the trial. While testifying, the court permitted Depp to read into record the title of an article, Johnny Depp was the victim of abuser Amber Heard, London's High Court told. Similarly, Depp's damages expert testified that Depp brought the UK proceeding to clear his name, which served to mislead the jury about the outcome of that proceeding. Second, a more fully described in section 3.5 below, the Sun article that precipitated the UK proceeding, Depp's decision to file the UK lawsuit, the trial and significant media attention, and the UK judgment finding that Depp had in fact abused Heard undoubtedly negatively impacted Depp's reputation. Nonetheless, Heard was precluded from presenting the jury with this highly relevant evidence regarding damages. Well, they did testify that his expert was able to testify that there was a court and that it did damage him, and the accusations did damage him. Heard was precluding from presenting the jury this highly relevant evidence regarding damages. Evidence of poor reputation is relevant to mitigating damages. Because of the prejudicial impact to Heard and given Depp's false and misleading testimony, the trial court erred by excluding evidence on the UK judgment. Stephen Deuters could not testify as to why he made those admissions. If Deuters was a... Okay, you got them mixed up. Stephen is alive, but he's not a U.S. resident, so he could not have been forced to testify, although I think he would have. Her mother has passed away. And so she could not testify, and the father they could not compel to testify. So Stephen Deuters is still very much alive and working for Johnny. Very good friends still. The trial court erred when it precluded Depp from answering a question about the truth of one of the allegedly defamatory statements. So backing up, this one I'm interested to see what LawTube has to say about if Johnny got any part of the trial into the record that he gave the jury impression he won. I did not get the impression because the damages expert that came on said that he was damaged. And the trial judge said that they could only limit damages to what they perceived from the date of the op-ed to the date of the judgment. So why would she do that if the judgment was to help him, I think? I don't know. I don't see that happening. Yeah, Jerry Judge is the one that would have testified. So I think we're getting Jerry Judge mixed up with Stephen Deuters. He could not testify because he had passed away. And he does have a declaration that they did not consider. Depp alleged that Heard defamed him by falsely writing in the op-ed, "I became a public figure representing domestic abuse." No, 2 years ago, I became a public figure. Let's get it all in there. On cross-examination, Heard's counsel sought to ask Depp whether that specific statement was accurate. Despite the fact that Depp was required to prove falsity of this statement as an essential element of his claim, the trial court precluded him from answering the question on the ground that it called for a legal conclusion. This was an abuse of discretion. Now, there's going to be a whole lot more in this transcript because Elaine kept asking, or was it Ben kept asking the question in different ways. But as far as on cross-examination, they want to know whether the specific statement was accurate. I became a public figure just representing domestic abuse. Well, it was a legal conclusion. It's a defamation. So allows testimony on an ultimate issue unless the testimony calls for an opinion that constitutes a conclusion of law. Whether a statement of fact is true or false is not a conclusion of law. Whether an allegedly defamatory statement is false ordinarily presents a factual question to be resolved by the jury. Well, first of all, they've left off the 2 years ago. They're already misrepresenting it. Heard clearly was prejudiced by this error. Depp's testimony that this statement was accurate, not false, would have required entry of a judgment for Heard on this particular claim. Granting summary judgment to defendant newspaper because plaintiff failed to carry his burden of providing the material falsity of any. So I guess they're saying that it was true on the face that 2 years ago she became a public figure because she falsely claimed Johnny Depp abused her. And that's what everybody thought this op-ed was about. Heard clearly was, and this is one of these knee-jerk objections that are made and ruled on that they give the judge a lot more weight on because they're not there in the court. They're not knowing what's going on around it. So this was one of those things that the judge gets a lot more strength on and support on than some of these researched and opined opinions on other motions. Yeah, we never knew what she died of. Never knew. Yes, that was not the full statement. Okay, despite the fact it was required to prove falsity of the statement as an essential element of his claim, the trial court precluded him from answering the question on the ground that it called for a legal conclusion. This was an abuse of discretion. Well, whether it was true or not as far as defamation is a legal conclusion. I don't know. Allows testimony on an ultimate issue unless the testimony calls for an opinion that constitutes a conclusion of law. Whether a statement of fact is true or false is not a conclusion of law. Whether an alleged defamatory statement is false ordinarily presents a factual question to be resolved by the jury. Heard clearly was prejudiced by this error. Depp's testimony that this statement was accurate, not false, would have required entry of a judgment for Heard on that particular claim. Granting summary judgment to defendant newspaper because plaintiff failed to carry his burden of proving the material falsity of any of these statements is a matter of law. The trial court erroneously admitted irrelevant and prejudicial evidence. On at least 2 instances, the trial court admitted irrelevant and unduly prejudiced evidence had nothing to do with this case, but allowed Depp to attack Heard's character. Well, yeah, that's what defamation is about. It's about credibility, and character comes into that. Evidence that is not relevant is not admissible. Evidence must relate and be confined to matters at issue and must tend to prove or disprove these matters or be pertinent to them. Evidence of collateral facts on those incapable of affording any reasonable presumption or inference cannot be accepted in evidence. In addition, relevant evidence must be excluded if its probative value is substantially outweighed by the danger of unfair prejudice or its likelihood of confusing or misleading the trier of fact. Evidence regarding specific instances of conduct of a witness, when allowed, normally is limited to cross-examination for impeachment purposes. I'm going to interrupt this 1 minute because I saw a question that's coming important. Deuters could not find the text messages on his end. Some of the texts brought in were an image of the text message. They actually were a spreadsheet. So it was somebody copy and pasted the text messages in, or somehow that's how they were pulled to like an Excel spreadsheet, which is not how any of the other texts were submitted. So that was one of the arguments by Depp's team. I'm sorry, let's go back to this. I just don't want to miss that one. Evidence regarding specific instances of conduct of a witness, when allowed, normally is limited to cross-examination for impeachment purposes. Extrinsic evidence related to those acts is not allowed. The reasoning underpinning this rule is that the admission of evidence of specific acts and the rebuttal evidence which would follow injects collateral issues into the case, which would divert the jury's attention from the real issue. Noting that the collateral issues rule precludes a party from calling witnesses to impeach witnesses' character. Well, I think this is about her donations. They haven't specifically mentioned it yet. The trial court committed reversible error when it admitted extrinsic evidence of Heard's pledge to donate money to charity. The trial court committed reversible error when it admitted irrelevant and unfairly prejudicial evidence related to a purely collateral issue. Heard's pledge to donate proceeds of her divorce settlement to charity in 2016. While a party has significant flexibility to cross-examine a witness and impeach her, the Virginia rules of evidence limit a party's ability to introduce extrinsic evidence to attack a witness's credibility. The specific instances of the conduct of a witness may not be used to attack or support credibility, and specific instances of the conduct of a witness may not be proved to be extrinsic evidence. The trial court improperly permitted Depp to introduce extrinsic evidence about Heard's pledge to donate $7 million to the ACLU and Children's Hospital to attack her character and integrity. Her credibility. That's what it was about. The pledge, which was announced 2 years prior to the publication of the op-ed, was not relevant to Depp's defamation claims and was unduly prejudicial. Indeed, Depp not only used this evidence during the cross-examination of Heard, but he introduced collateral evidence, including witness testimony from representatives of the ACU and Children's Hospital about the pledge, for only one purpose: to prejudice the jury against Heard and paint her as a liar. Yeah, paint her as a liar. That's part of credibility issues in a defamation trial. And that's because you wanted the entire world to think you were donating every penny of the $7 million divorce settlement as soon as you received it from Mr. Depp. Isn't that right? So as of today, you have not paid $7 million of your divorce settlement to charity, right? And that's because you did not want something. You wanted Mr. Depp's money. There's a lot of ellipses here. There's a lot of stuff missing. Lies. That is Miss Heard's narrative, lies upon lies. The testimony created a mini trial on what Heard donated, what her intent was, and whether she intends to fulfill the remaining pledge. Again, none of this related to the op-ed or whether Depp abused Heard. It goes to her credibility. It goes to her preponderance to lie to the public, to get what she wants, or to be perceived a certain way, or to use lies to elevate her status, which again goes from the TRO to the op-ed that she wanted to be the speaker on a pedestal. She wanted to be the Me Too poster child. Debbie, I am not worthy. Thank you, my dear. Early Merry Christmas. Happy New Year. You're the greatest, and thank you for all your dedication and work. Blown away, Debbie. Please, you're so generous. Thank you so very much. I'm like breathless on this. Thank you, retired Nana. Would you agree that Amber's op-ed was not an opinion because she made it about herself? Would it be an op-ed if she just generalized SV and DV and take it? I think a lot of people said that if she had only talked about not her experiences, not mentioned 2 years ago. Anyway, yeah. I want to get back to this ACLU. This was heavily litigated in California. So again, Fairfax issues, let me jump back. Fairfax issues the subpoena. The subpoenas are brought to or served on the people or the companies. But once that happens, the local law takes over about how those subpoenas will be applied. ACLU was in New York. We saw that played out in a different way. The Children's Hospital was in Los Angeles. So the California courts heard that because Amber Heard tried to quash the subpoena. Depp, of course, came back against it. One of the things that the judge said is when you made these public statements, you made this part of your character. You made this is no longer private. She was trying to argue that all these donations should be made private. And they said, no, once you went out to the public and said, I am doing this, and these are the reasons why, you made it part of the public. You made it part of your credibility. So the California judge enforced the subpoena and sanctioned her on this. So I just want to know that it wasn't just Judge Ascarate. It was the California judge also said, no, you've put this at issue for your credibility. And therefore, I'm not going to quash the subpoena. I'm going to enforce it and I'm going to sanction you. The trial court committed reversible error when it admitted extrinsic evidence of Heard's alleged domestic abuse more than a decade earlier. The trial court also allowed improper impeachment of Heard when, in rebuttal, and we know this came out in the unsealed documents, Depp presented testimony of Beverly Leonard, a police officer purportedly present when Heard was arrested in 2009. The court clearly erred when it admitted this evidence in an entirely collateral issue. During cross, Depp asked Heard about domestic abuse he alleged she engaged in during a prior relationship. Heard denied the allegation. That would have been the end of it. However, the court permitted Depp to call Leonard, a former police officer, to testify that in 2009, she saw Heard acting aggressively toward her then partner, grabbing her partner, pulling her necklace from her neck, permitting extrinsic evidence of an incident that occurred 9 years prior to the publication of the op-ed, and allowed Depp to paint Heard as a bad person. Holding the lower court committed reversible error when it allowed extrinsic evidence on collateral issue to impeach defendant's credibility. The court's decision to admit Leonard's testimony regarding an incident that occurred 9 years before the publication of the op-ed serves no legitimate purpose. This was decided after Amber Heard had said on the stand, I know you can't hit a woman. I know you can't hit a man. I know you can't hit anyone. And that's specifically the statements that Ben Shue took to the courts on the Fridays. They do all these motions that said, hey, she just opened the door for us to bring this in. And it was limited. It wasn't near as much as we had hoped. But it was brought in. The trial court's evidentiary rulings encouraged the jury to award damages unrelated to the op-ed. Have I missed anyone? The trial court's erroneous evidentiary rulings also left the jury without crucial evidence regarding Depp's reputation and therefore prevented the jury from accurately assessing any harm proximately caused by the op-ed. First, the trial court erroneously excluded as hearsay articles relevant to Depp's reputation prior to the publication. Well, I remember Ben Ronberg reading clickbait title after title after title and not allowing Johnny to comment or explain any of these things. The articles, however, the first trial court excluded the articles as hearsay. The articles, however, were not hearsay, as Heard sought to admit them as not for the truth of the matters asserted in the articles, but to show the state of Depp's public reputation prior to the publication of the op-ed. Evidence of prior or contemporaneous publications is admissible to mitigate compensatory damages. Well, all those articles were read in, all the titles at least, which were obviously clickbait at their worst. And so what? He was still being hired. He was still popular. Second, the trial court excluded relevant evidence related to the UK proceeding, including the Sun article and the UK judgment. At a minimum, the jury should have been permitted to determine whether it was appropriate to apportion any claimed reputational damages between the op-ed and the Sun article, and the judge did limit the time. The judge said you could only quantify damages from this point to this point. And Johnny's expert witness said, hey, that op-ed was a call to action to stop working with Johnny. That's the straw that broke the camel's back. He's been harmed, and somebody else had said this. It's like when you're in a terrible car accident. You get in a car accident and you get injured and you escape from that accident, and then you're walking away and you get hit by another car, but you survive that. And you get further on and you have terrible injuries, and then somebody stabs you. And then you die. Yeah, you were in terrible shape. Things were going wrong. Who knows if you would have lived at that point? But once you were stabbed, that was it. You were done. You were dead. And a lot of this is, yeah, maybe Johnny's career was getting harmed along the way, but he was rebounding, and they showed that, and he was getting harmed and he was rebounding, and that this op-ed was basically the nail in the coffin. This was the straw that broke the camel's back. This is what caused the issues going forward. Because a lot of people didn't care what happened in England, in the UK. It wasn't really reported here in America. Not that much. Should have been permitted to determine whether it was appropriate to apportion any claimed reputational damage between the op-ed and the Sun, and the judge did quantify those dates. Upholding admission of prior and contemporaneous articles to mitigate damages because the defendant could not be held liable for injuries that it did not cause. Indeed, the trial court agreed that this evidence was relevant, but it nevertheless precluded Heard from introducing the Sun article, the UK judgment, and the published media reports. Headlines of these articles include, but we're not limited to, Johnny Depp, friends and family seriously concerned about him. Here's why. Hearsay. Sources close to, unnamed people, right? That's hearsay. Johnny Depp, a star in crisis, and the insane story of his missing millions. Hearsay. I mean, if you're going to bring these articles in, you've got to bring in the writers, I guess, and who they're quoting. Johnny Depp reportedly drunk heavily and was constantly on the new Pirates movie. Again, rumors and hearsay. We heard from his agents, both of them. We heard from Disney. This is hearsay. Johnny Depp's financial woes might sink the next Pirates of the Caribbean. I'm not sure even why that has anything to do with it. Where did it all go wrong for Johnny Depp? Opinion, hearsay. After a string of flops and a ton of bad press, Johnny Depp's star power looks as wobbly as Jack Sparrow on the plank. String of flops? No. The trouble with Johnny Depp, multi-million-dollar lawsuits, a haze of booze and hash, a marriage gone very wrong, and a lifestyle he can't afford inside the trials of Johnny Depp. So, again, the lawsuits, he settled, I think, positively for almost all of them. He went through rehab. The marriage gone wrong because, well, we heard the testimony, what was happening, and the jury fell on his side. Vodka for breakfast, 72-hour drug binges, and spending sprees that beggar belief. Reveal why Hollywood's reeling over what's being called Johnny Depp's career suicide note. Yeah, he said that, I can't believe all this happened to me. I'm a good person. I did all the right things. I help people. And I'm suddenly accused, falsely accused, and my life is wiped away. And I would wake up in the morning and type and have a glass of vodka until I couldn't see through the tears anymore because I was falsely accused. That's what the whole article was about. How can J.K. Rowling be genuinely happy casting wife beater Johnny Depp in the new Fantastic movies? Regarding the UK proceedings, similarly by precluding Heard from admitting the UK judgment, the jury was left with the false impression that Depp's reputation, because of the UK proceeding and the significant corresponding media attention by November 2nd, the world already saw him as a DV, domestic abuser. Nonetheless, the trial court kept that critical information from the jury. Well, they're part of the world. I mean, if they didn't already know about it, then a lot of people didn't know about it and didn't care. So it's not like they were ostriches with their head in the sand for the last 5 years. If the whole world already saw him that way, then so did this jury. They're every man, right? Given Depp's claim that the op-ed accused him caused him significant reputational harm, it was critical that the jury hear relevant information regarding his baseline reputation. They did that. We have said that one with an unblemished reputation is entitled to more damages than subjected to defamatory statements when one's reputation is a little hurt by the statements. Well, yeah, he wanted $50 million. He didn't get that. He didn't get it. The jury decided this is how we think you were damaged in this time period based on all the testimony we heard, which included the experts from both sides. The effect of a bad reputation is to reduce the damage inflicted. Because of the trial's court's decisions, Heard was prevented from establishing that Depp could not have been harmed by publication of the op-ed because he already had a terrible reputation, but he was still working. He wasn't awful. He still had Pirates of the Caribbean in negotiation and talks, at least according to his agent. They were still talking. They were still hopeful. And then 3 days after the op-ed, Disney made that decision. They may have been still hopeful. If it wasn't for the op-ed, 6 months later, when everything was over and done with, maybe they would have hired Depp. But the op-ed precluded that. That was essentially the straw that broke the camel's back, is what they were claiming. Thank you, Charlie. Is telling the age only wants the UK verdict admitted and not the entire case to include that wasn't a party and constantly twist the judge. Yeah. I mean, if I'd be shocked that nobody on that jury actually ever heard any of it, but I was there for voir dire and they were like, yeah, they didn't really follow it that closely. So their claim that the entire world would have known this kind of falls short. Also, her making a first-person account about the abuse she alleges is different from random articles. Pathetic attempts. Appreciate you, Laura. Thank you so much. Thank you for the super chat. Thus, while the jury was allowed to hear testimony of Depp's harm as far back as 2016, the jury was not able to fully assess the reputational harm unrelated to Heard's op-ed or the impact of the judgment that found Depp to have committed acts of domestic abuse, including sexual violence. Well, again, the case was treated so differently and tried so differently than here. Obviously, the outcome is different. They didn't believe she was telling the truth. Regardless of the damages, the jury found she lied. So they came to a different conclusion because they had a different system. As discussed more fully below, the impact of this error was compounded by the separate error in permitting Depp to claim damages based on conduct unrelated to the op-ed, including the 2016 restraining order. All of this resulted in indefensible $10 million compensatory damage verdict and $5 million punitive damage verdict, a verdict that demands reversal. Well, they're going to argue that they very much defined the loss and they wanted $50 million. And the jury reasoned that $10 million was enough. They also reasoned that $5 million punitive damage was enough so that nobody would ever make this claim against Depp again or repeat this claim. They didn't note that the UK trial JD wasn't able to cross-examine the witness plus bias. That's a confusion to me because I'm not a lawyer, but I know for a fact that Sasha Wass introduced Amber Heard. This is your witness statements, you fear all this, etc. And then Eleanor Laws, Johnny Depp's attorney, questioned her. And then when she was done, Sasha Wass was able to question her. What I didn't see that was so different than the US was any kind of rebuttal. You know, you didn't have that really rebuttal. So I do know that Eleanor Laws questioned Amber Heard just as Sandra Wass, I think her name was Sandra Wass, had questioned Johnny Depp. The trial court erred by not dismissing the claim based on the headline for the web version of the op-ed because the evidence established that Heard did not publish it. She republished it. The trial court erred by not striking evidence or setting aside the jury's verdict based on Depp's failure to prove a required element of one of his claims that Heard published the challenged headline of the online version of the op-ed. I spoke up against sexual violence and faced our culture's wrath. This has to change. Publication by the defendant is an essential element of a claim for defamation. In reviewing a trial court's denial of a motion to strike evidence or set aside a jury verdict, the court considers whether the evidence presented, taken the light most favorable to the plaintiff, was sufficient to support the jury verdict. The undisputed evidence established that the Washington Post posted the headline without Heard's knowledge. Heard testified that she did not notice the headline when she tweeted the link to the op-ed. That's not credible. She tweeted it and commented on it. And what didn't come out at trial, sadly, was she also screenshotted that with the title and posted it on her Instagram account. Yeah, the jury saw her anthill of evidence. What they saw was Johnny's mountain of credible evidence rebuting her. The trial court denied Amber Heard's motion limited to exclude and redact the headline because she republished it. She commented on it to her own people, and she never asked for it to be changed. Why didn't she say, oh, wait, sorry, I never said that about Johnny. Can you correct that, please? Can you make that very clear? Ever. She did not notice the headline when she tweeted a link to the op-ed. Thus, there is no evidence that Heard published the headline. Indeed, Depp effectively conceded this, his theory being that Heard republished the headline when she later tweeted a hyperlink on the op-ed. But courts consistently have held that providing a hyperlink does not constitute republication, even in a tweet that favorably references the article. But it does if you add commentary and you're sending it out to a new audience. Then it's a republication, and that's what they believed. A mere hyperlink without more cannot constitute republication. There was more. Publishing a favorable reference with a link on the internet does not republish the article. There was more. There's simply no evidence that Heard republished or published or republished the headline. Yeah, there is. She added commentary to it. She retweeted it with commentary, with the link out to her people. It had the title in the link. As soon as she hit published, it's there. I don't know why people think they can tweet and run and not be responsible for it, but it's there. She never denied it. She never asked for correction. Thus, the trial court erred in two ways. First, the trial court's refusal to exclude the headline from the evidence led to the introduction of irrelevant and prejudicial evidence and arguments about whether Depp had committed sexual violence against her, a phrase that does not appear in the challenged portions of the op-ed. She claimed it. Maybe she shouldn't have claimed it. Maybe this would have carried more weight if she didn't suddenly come up with these new accusations that were not included in her April 11, 2019 declaration that was filed in Virginia, where she listed multiple allegations of abuse, but not one claim toward SA. Thank you, Mary. So appreciated. Thank you so much. Thus, the trial court erred in two ways. First, the trial court's refusal to exclude the headline from the evidence led to the introduction of irrelevant and prejudicial evidence and arguments about whether Depp had committed sexual violence against Heard, a phrase that does not appear in the challenged portions of the op-ed authored by Heard. So why didn't she just say that? Instead, she came out with all these SA claims. She put it on her Instagram account. I'm sad that they missed that. As opposed to other forms of abuse, the word that Heard did use, thus infecting the jury's verdict as a whole. Second, because the jury awarded Depp $10.35 million for all three challenge statements together, there is no way to know how much of the award is attributed to the headline that Heard did not publish. I would say 90% of it went to the 2 years ago I became, because that's what introduced him into the op-ed, my opinion. The only remedy for these errors is to grant a new trial on both liability and damages, but at the minimum, this second error requires a new trial on damages. The trial court improperly instructed the jury on actual malice. I need a drink, guys. Get in there. The trial court refused Heard's proposed jury instruction, which set forth the CC, they all had numbers or letters, they're not in any specific order, which set forth the cumulative intent prong of actual malice that Depp was required to prove by clear and convincing evidence for his defamation by implication claims. As a result, the instructions given to the jury on actual malice were missing the crucial component of the standard, and a new trial on liability, therefore, is required. The trial court gave two jury instructions defining actual malice. Instruction AA addressed only the falsity prong of actual malice. Instruction BB correctly clarified that actual malice is not established by ill will or hatred. It's not malicious. Heard's proposed jury instruction CC, which the trial court refused, addressed the communicative intent prong of actual malice that must be established when, as here, the claim is for defamation by implication. That is, The jury should have been instructing that it is also must find by clear and convincing evidence that Miss Heard either intended to communicate the defamatory implication or knew the defamatory implication with reckless regard to it. Well, I think that's what they found, that she intended to implicate him and that it was a lie. Should have made clear that Miss Heard intended to communicate the defamatory implication. I think that still goes to the same one. When considering whether a jury instruction was properly refused, the evidence is viewed in the light most favorable to the proponent of the instruction. If a proffered instruction finds any support in credible evidence, its refusal is reversible error. As explained above, Depp presented no evidence that Heard either intended to communicate through the op-ed that he engaged in domestic abuse or knew of the defamatory meeting and was reckless in regard to it. Well, she did announce it during her testimony that it was definitely about him. To the contrary, the evidence showed that Heard made significant errors to eliminate any such innuendo. She said 2 years ago. 2 years ago, this happened to me. And I think that's what did it. The trial court's improper refusal of proposed jury instruction, CC, requires reversal of the judgment and demand for a new trial. This is what I'm hearing. She admitted twice during the trial that the op-ed was about JD, and others that during her last visit to the stand said it was about him. Yeah, because he was a man of power. That's why it was about him. Jury verdicts that are irreconcilably inconsistent cannot stand. Here we go. If there is no reasonable way to harmonize the verdicts based on the evidence presented at trial, the new trial should be granted. To reach the verdict against Heard on Depp's claims, the jury necessarily found that Heard had not been abused by Depp and that she knowingly lied in stating that he had abused her. Yet at the same time, to reach the verdict in favor of Heard on one of her own defamation claims against Depp, the jury necessarily found that Depp did not lie about being, that's not what they found. They did not say that she lied, did not lie about the victim at the hands of Depp, specifically during the incident. This case involves two essentially mirroring image defamation claims asserted against only two people who truly know whether the statements at issue are true or false. If Mr. Depp did not abuse Miss Heard, she indisputably knows her claim then that he did is false. If Mr. Depp did abuse Miss Heard during their brief marriage, he knows that Mr. Wallman's statements calling Miss Heard a liar is false. Thus, the trial court erred in declining to set aside the jury's verdict against Heard on the ground that it is inherently and irreconcilably inconsistent with the verdict against Depp. The judgment against Heard should be reversed and the case remanded for new trial. The Virginia Supreme Court has instructed that courts have the duty to correct a verdict that plainly appears to be unfair and would result in the miscarriage of justice. Setting aside a jury verdict is necessary when the award is so excessive that it shocks the conscience, creating the impression that the jury was influenced by passion, corruption, or prejudice. When the jury has misconceived or misunderstood the facts of law, or when the award is so out of proportion to the injuries suffered as to suggest that it's not the product of a fair and impartial decision, if the size of the verdict bears no reasonable relation to the damages disclosed by the evidence, it is manifestly unfair. A trial court's denial of a motion to set aside the verdict as excessive is subject to review for abuse of discretion. Thank you. 2 years ago was strategically put in there. She wanted him mentioned in there so badly. We saw the emails going back and forth. And at the end, they said, damn the torpedoes. Let's do it. Debt damages are limited to the narrow period between the publication of the op-ed and the issuance of the UK judgment, December 18, 2018 to November 2nd, 2020. Depp represented he would not seek damages for after November 2nd. Depp failed to prove any pecuniary damages resulting from the op-ed during that time, and he did not seek emotional distress damages, leaving reputational harm as his only possible source of damages, or his loss of work, actual loss of work. Reputational harm goes, he might have got more jobs, which is absolutely true, but he also lost Disney. The jury's verdict of $10 million in compensatory damages is grossly disproportionate to any reputational harm the op-ed could have caused during that small window of time. Not true. 1 or 2 movies and all the percentage of the box office and then the future residuals. That's not true. Johnny easily could have gotten $2-3 million movies or $4 million plus all the back profits and proceeds and ongoing and possible future more jobs. That's not true. In my opinion, that's not what I'm saying. First, there is no evidence upon which the jury could rely to determine Depp suffered any pecuniary loss because of the op-ed. Depp principally claimed that he lost a role in Pirates of the Caribbean. 6, because of the op-ed, but the trial record does not support such a conclusion. As an initial matter, Depp failed to establish that he actually had the opportunity to act in Pirate 6 and then lost it. He did not have a written contract for the film. Even before the op-ed was published, the media reported that Depp would not be in the film. That's not by Disney people. And his agent testified that Disney was non-committal. Non-committal means not yes or no, but it definitely means no about giving Depp the role. And at any rate, Depp testified that he would not have agreed to play a role in Pirate 6, even for $300 million and $1 million alpacas. Yeah, he said that in his deposition. He's pissed. He was pissed the way he was treated. Depp also did not prove that he lost the opportunity to appear in Pirate 6 because of the op-ed. Disney's corporate representative, I love this because I'm doing a video on this, testified that no decision maker within the company had ever said they would not cast Depp because of the op-ed. That's not what she said. She said, as a production manager, I would not be aware of any of these decisions. That's way above my pay grade. Nor did Depp present any evidence that he lost other opportunities because of the op-ed. For example, Depp still has an endorsement deal with Dior, which began in 2015. Yeah, people stood by him. That's why his reputation wasn't completely wiped out. But yeah, she did significant damage because she is the first person claimant. This isn't like the Sun saying, we think he's an abuser because we believe this. She says, I was abused. That gives it way more weight. And that's what the experts are trying to say. This is now first person testimony of it. That's giving it way more weight than anything else that could have happened, is what the experts were saying. And as far as Disney, the corporate representative, they were supposed to send their person most knowledgeable, and they most certainly didn't, because this person had no idea and said multiple times, I would not be part of this decision-making. I would not be part of getting that information. I would not be part of these verbal discussions. That's above my pay grade. Given that the jury could not have awarded Depp damages for any pecuniary losses based on the evidence at trial, obviously the jury did not agree because they didn't give him his $50 million. They came to that number somehow. And Depp never sought emotional distress damages. The only damages the jury could have, general reputational, did I like, resulted from the Depp that's wrong and not in other clauses. Is that a repeat or did I roll back? Sorry, guys. The trial court improperly admitted evidence that encouraged the jury to award damage for conduct unrelated to Heard's op-ed. This is why Disney's begging Johnny to come back for 1 or 2 pirates. I don't know. That's gossip. But thank you. I'm sorry for freaking off of me. Thank you, retired on it. Yeah, well, that's gossip. I don't know. One outlet said he was, and one outlet said he wasn't. So I don't know. The trial court improperly admitted evidence that encouraged the jury to award damage for conduct unrelated to Heard's op-ed, specifically evidence of reputational harm stemming from Heard's 2016 restraining order. Depp's trial theme was a plea for the jury through its verdict to rectify the damage Depp suffered as a result of the restraining order. On May 27th, Ms. Heard walked in the courthouse in Los Angeles, California, to get a no-notice ex parte restraining order against Mr. Depp, and in doing so ruined his life by falsely telling the world that she was a survivor of domestic abuse at the hands of Mr. Depp. Today, on May 27, 2022, exactly 6 years later, we ask you to give Mr. Depp his life back by telling the world that Mr. Depp is not the abuser Ms. Heard said he is, and hold Ms. Heard accountable for the lies. This was in their closing statements. Closing statements are not evidence, and the jury is told not to consider that as evidence. Opening and closing statements are not to be considered. Only what's presented at trial. What was presented was the op-ed, was basically the republication claiming of what happened to her 2 years prior. These sentiments permeated the entire trial. According to Depp, when Heard obtained the restraining order, he lost nothing less than everything. He explained when the allegations were made, when the allegations were rapidly circling the globe, telling people that I was a drunken, cocaine-fueled menace who beat women. Suddenly in my 50s, it's over. You know, you're done. But are you done? Because he was working. And the experts testified that once the op-ed came out, the first person written op-ed, this happened to me, it was a call to action to not work with him anymore. That's what the expert said. And I think that impacted the jury very much so. In fact, Depp's testimony began with an explanation of why he brought his case. About 6 years ago, Heard made some quite heinous and disturbing, brought these certain criminal acts against me that were not based on any species of truth. Depp also testified that after the public became aware of the restraining order, the bad news about him was multiplying throughout social media as well. Even Doug's expert, Doug Banya, that's the one, who Depp retained to analyze the impact of the allegations on Depp's reputation, could not say that Depp's reputation or public image was affected by the op-ed as opposed to the events. That's not what he said. He said that op-ed was a call to action. That was his words. I think he's on rebuttal. And that it carried extra weight because it was directly from her and not what else was being reported in the media. Because Depp improperly was allowed to suggest that the jury could award damages based on statements Heard made prior to the publication of the op-ed, and the jury was not informed of the outcome of the UK proceeding, the jury's damage award is wholly out of proportion to the reputational damage Depp actually could have sustained as a result of the op-ed. If they believed he lost Disney because of that op-ed, it is clear from the size of the compensatory damage award that the jury intended to award damages not just for the op-ed, but for all of the negative publicity that Depp had received since Heard first accused him of abuse in 2016 and continuing after the UK judgment. This is an impermissible basis for damages in this case. At a minimum, the jury's excessive damages verdict could be reversed and the case should be remanded for a new trial. Conclusion: for the foregoing reasons, Heard requests that this court reverse the judgment against her and either A, enter a judgment for her or dismiss Depp's claims without prejudice, which would go back to California, or remand for a new trial. And I would love to know the answer for if they remand a new trial, God forbid, does that mean Johnny has to take the impetus to actually bring it again, or is it automatic? So it's been given everywhere, 57 pages. He was given, 55 pages? I'm not sure what constitutes, like maybe this doesn't count page, but I would assume it's a signature page. That's what we have, guys. That's what we have. Yeah, let's take a look. Let's have a discussion here. What are some of the things I brought up? The Jaw absolutely said that it was that Depp should be allowed to have access to subpoenaing and deposing Children's Hospital because she made it public, and she goes to her credibility. ACL fought it. They lost. The judge also agreed on every but one account, 22 out of 23 requests, that they must abide, and I don't think they were sanctioned. Hopefully this will not go anywhere. They've put a lot to this appeals court, basically saying your two chief justices screwed up so royally, wasted taxpayers' time in 6 weeks, and this jury must be so unreasonable. That's huge. And they have to pick any one of these or multiply these that the whole thing gets turned over. That's a lot. I applaud your calm demeanor in reading all this whoopla. I'm spouting off as this thing that's been filed in court. Yeah. Thankfully, I'm not seeing anything new here in that none of this went unopposed during the trial. I mean, she had how many lawyers going through this, filing for dismissals, filing against all of these things, dismissal, demurs, limiting things, limiting Johnny's, that so many eyes looked at this multiple times. Judge Ascarati, they presented it multiple ways, not just dismissals, but then the summary judgments, then the dismissal after the case was presented. It was visited so many times, I can only hope that there's no more room for error. They remember this entire appeal will be judged in the best light of Depp, who won, and the best light of the jury who was there. They don't second guess the jury so much because they were there, they were in the court, they heard, they saw. The same with Judge Ascarati on rulings that she had to make during the court. She was there, she heard it. She made the judgments in those moments. It's going to be a lot more of the pretrial and the motions on limine. I mean, nobody believes that she can win on the UK judgment. The inconvenience, the location being that should have been Los Angeles, was ruled on way back by Judge White, and they were allowed to do deposition testimony, and they were allowed to do WebEx. Nobody stopped them from doing WebEx, but none of her witnesses wanted to. Yeah, I don't know what she's been doing with the money. I mean, she's been working. Yeah, keeps things simple. So we're going to get, well, my understanding is, Depp, where do we go from here? All right. I know that Johnny, as soon as she asked for an extension, they also filed for an extension. And it was unopposed. In other words, Amber Heard's lawyer said, yeah, go ahead. We'll give them the extension, give them the extra pages too. The court ruled against Johnny, or no, the court said they will not make a ruling at this time because what Johnny's asking for is clearly dependent on a date of when this was received, which we now know is 11/23. So if they allow his request, I think it goes into January. He was requesting, he was asking extra pages. So I expect that motion will be come back alive and be ruled on now that we have a specific date for the court to work from, that he'll get some extra time and some extra pages is what I'm understanding. There was very, very little argument about legal errors. It was a rehashing of evidence. It was poisoned. It has poisoned the court's well with unnecessary words. It may not be looked on favorably. They cannot allow someone to give evidence and not allow evidence that they are prepared to lie in public under oath. That's true. You're so welcome. I'm glad I could bring this to you. I am so interested in the law tubers dissecting this, but everything we've heard, they already talked about between the amicus brief. A lot of this was a little bit previewed in, and in her original list of errors, assignment of errors. So she's done all 16 of them. I don't see this filing going anywhere. It's too long. As a criminal attorney in Virginia stated, once an appeal filing goes over 10 pages, the appeal judges tend to ignore it. This isn't just like an issue of 10 pages. This is an issue of 16 errors. 16 errors. Like your Virginia court, your two chief justices got it so horrifically wrong. You should be embarrassed and retry this or throw it out. That's a hell of a big statement. Yeah. I said that, well, first of all, she's working with her insurance company to still have everything paid for, including her appeal. But Johnny's having to pay for all of this out of pocket. And again, if it goes to a second trial, I'm not assuming it will. We're just talking about what's being requested here. That, again, he'd be paying for it. Depp actually said in the audio tape, if it doesn't go your way, I'm in trouble. And this is exactly what's happening. It's not going your way and she's losing it. Yeah. I think this goes to, as far as reputational harm and the damages, Johnny was working. He had lost Fantastic Beasts after the November 2nd, and he didn't claim damages for that. That was never brought up. He claimed damages for the loss of Pirates. He claimed reputational damage, which means I wasn't getting any other jobs maybe I would have gotten. You know, just because your reputation and your career is going down, it doesn't hit rock bottom. It can come up. And they showed that his likability and stuff was coming back up. He got more work and then he didn't. And then when he wasn't getting the big franchise jobs right after her claim, I'll tell you what they dropped. They dropped the claim of the October, hey, Business Maven, how are you? Sending you big hugs, big hugs. She was an amazing judge, amazing judge. I was going to say, I just saw Business Maven. I know she's been going through a rough time and sending her hugs. They didn't bring up the October article with, I can't remember his name was Beatty. They caught this guy in the red carpet. Well, Johnny's name was big clickbait. And you saw these from the articles. They were constantly tearing him down because people wanted to read about it and they got the ad revenue. So one of them was on a red carpet, this guy who had been a writer on the first Pirates of the Caribbean only. They caught him on the red carpet and they said, what do you think if Johnny might not return as Captain Jack Sparrow? And that was his question. And he assumed that they knew what they were talking about. He assumed they had inside knowledge that he didn't have. And he says, well, I think Johnny's had a great run, etc. So that's the article they tried to use. It was definitely hearsay. This guy does not work for Disney. He had no idea whether Johnny was still being considered or not. And Carino said they were still talking. They were still hopeful. Bruckheimer was still hopeful, that I think as far as Carino had testified to. So it really is a matter is, when are you done? Are you done? Are you hurt more? Yeah, I think you are. I think Banya's statement was the strongest. This is the person who would have known that he said, she said, not any of the articles, not any of the tabloids. This is the person who would have known what happened or didn't happen. She claimed it happened. She reiterated in the op-ed 2 years ago, I suffered this. And it was basically a call. He said it was a call to action. Do not work with him anymore. So I think that's the strongest. Oh, the strongest. Hey, Amy, how are you? This is Amy Goodhart. This was the gal that went with us to Vegas. Friends of Andy was the neighbor in the Eastern Columbia building. Hey, Amy, how are you? Nice of you to join me. So I think that's the strongest. Any other questions that you think? I mean, I'm not the lawyer. I can only tell you what I remember. I know a lot of this was litigated in California and it was all allowed in. We saw it heavily litigated about the UK judgment, and then the judge reiterated that it's not the same system. It's not the same article. It's not the same jury versus judge. It's not, she was not the party. She would not have been damaged the same. Johnny's name was, yeah, they wanted this. They said the first ones, can you write about this horrific thing that Johnny did to you? Can you help us out? That's what the whole premise of it was. And that's about it. So what's it? Anything else? I still think it comes down to, you can't undo. The jury decide. The jury heard it. The jury heard all the testimony. So I'm waiting to hear what the law tubers say about the pre-trial motions. If that just says you can't listen to what the jury, what happened at trial then. Yeah, I have a great video that I just done. I did it before Thanksgiving because I wasn't sure what was going on with all the briefs, and I'll put that out next about how Amber Heard's team tried to manipulate Disney to limit their discovery in favor of her, and how they ended up, they both wanted to sanction, I mean, she wanted to sanction Disney. So it's be really interesting. Yeah, I think I'm going to let everybody go. I've been on here for, oh my God, 2 hours and 40 minutes. That's like ages for me. So I think this is it. I'm pretty sure that we're going to get a lot of other law tubers giving their legal twist on it, which is what you need. This was the pre-read, cold read with my background information of what I know I learned going through this and with the California courts. So thank you everybody for coming by. I'm going to end this now. I thank you all for your support. I so appreciate it. I think I got all the super chats that I went through. I don't think I missed any. So I am going to sign off, guys, and get ready for the law tubers that are going to come behind me, because it's going to be a long day of videos. Love you all. Thank you for joining me. Like, subscribe, hit that bell because it's being unrun by YouTube for some reasons. I will add some links below that I tried to promise you I would have. I have to think about them, what they were. Oh, some of the Fairfax rulings I want to put down here so you can compare and contrast what Judge Ascarati and Judge White had posted. So I am going to go now. Thank you all and have a great day.